line. I appreciate you speaking up. There any other commission?
Commissioner Coleman is here.
Okay, and Commissioner Coleman, could you speak up for me one more time so I can figure out which line is yours?
Testing. Testing.
Thank you very much.
You're welcome.
Okay. It's helpful to know who is here. And it looks like, let's see, you have another connection, Commissioner Coleman, that we might have to disconnect, because right now you have an audio connection and then you've got another one that I had to mute.
Well, I'm having an issue where I can't get audio for some reason on my computer, so that's why I also followed up and called in on my phone.
Okay. Is it working okay for you right now so that you have a video?
I'm not getting the audio on my computer, however.
Okay. Okay. And it sounded like what happened was it tried to connect by phone and then it went to your voicemail.
Oh, okay.
Is what had happened there. I don't know if you would like to try again or not.
Yeah, try again. Let me just disconnect everything and call back real quickly, okay?
Okay, thank you very much, Commissioner.
Thank you.
Hello, I hear someone is connected.
This is Henry Robertson for the Sierra Club.
Okay, and you're connected by phone. Could you speak up?
Yeah. If it hadn't begun yet.
Thank you very much. We are actually giving Commissioner Coleman a chance to get connected here this morning, and then we are going to get underway.
On video.
And I'm back.
Okay, and now we have Commissioner Coleman, it sounds like?
Yes.
Okay, and I'm going to ask you to just speak up for me one more time and say hello, and then hopefully I'll know which line you're on. Thank you.
Good morning to you.
Okay, it looks like you've only got one line at this point. Is that connection working?
Yes, it is. It's perfect.
Okay, thank you very much, Commissioner Coleman. Okay, I think we are ready to get going here this morning, so let's bring this proceeding to order. We are now on the record. Good morning. Today is November 12th, 2020. The time is 9:08 a.m. The Missouri Public Service Commission has set this time for an evidentiary hearing in case number EU 2020-0350, which concerns the application filed by Evergy Metro Incorporated and Evergy Missouri West Incorporated for an accounting authority order allowing the companies to record and preserve costs related to COVID-19. My name is Jana Jacobs, and I'm the regulatory law judge assigned to this case. As you know, the commissioners are Chairman Ryan Silvey, who is present with us at this time, Commissioner William Kenny, who is also present with us on the line, Commissioner Scott Roop. I'm not sure if Commissioner Roop is with us. I hope commissioners will speak up when they join us.
I am here, Judge.
Oh, thank you very much, Commissioner Roop. Will you say hello one more time for me?
I am here. And
okay. Wasn't able to find that line, but oh, yes, I see your name. Thank you so much, Commissioner Roop. We also have Commissioner Maida Coleman on the line with us this morning, and Commissioner Jason Holzman is also on the commission. I don't know if Commissioner Holzman is with us or not this morning. So those are the commissioners, and we do have several of them with us here this morning for the hearing. We are going to start with entries of appearance. I'm going to note for the record that Missouri American Water, Spire, Missouri, and Ameren, Missouri have been excused from appearing, so they will not be making appearances today. And to save time this morning, if your current mailing address, phone number, and email address are on the record in this case, you can enter an appearance this morning simply by introducing yourself, stating your name, and letting the commission know what party you represent. That'll save us a little bit of time in the entries of appearance. So we can get started with counsel for Evergy Metro and Evergy West, please.
Thank you, Judge. On behalf of the applicants in this case, let the record reflect the appearance of Robert J. Hack, Carl Zobrist, and myself, James M. Fisher, and our contact information is on the application and other pleadings in the case.
Okay, and appearing here today, I know you're here, Mr. Fisher, and Mr. Hack, I've also seen him. Is it just the two of you, or is there any other counsel on the line this morning?
I think Carl Zobrist is in the conference room in Kansas City.
Okay, thank you. That's the information I needed. Is that right? Is Mr. Zobrist present in Kansas City?
Yes.
Okay, thank you. So we can proceed to any entry of appearance for staff, please.
Good morning, Judge. My name is Jamie Myers, and I represent the staff of the Missouri Public Service Commission, and my address and phone number on record.
Thank you very much, Ms. Myers. We can proceed to the Office of the Public Counsel, please.
Good morning, Judge. Caleb Hall appearing on behalf of the Office of Public Counsel. My contact information has been included on various filings in the record.
Thank you very much, Mr. Hall. And we can move on then to Midwest Energy Consumers Group, please.
Morning, Your Honor. David Woodsmell for MECG.
Okay, and I wasn't able to tell Mr. Woodsmall if you're, oh, there you are. I see your video now. Thank you. All right, and then for Missouri Industrial Energy Consumers, please. And I'm afraid that you're muted, Ms. Plesha. Sorry, that happens to me all the time.
Thank you. I'm Diana Plesha of the law firm Curtis Hines, Garrett and O'Keefe.
Thank you very much.
Consumers, thank you.
I'm sorry I ran over you there. We can now proceed to National Housing Trust.
Sorry, can you hear me?
Yes.
This is Andrew Linares, representing the National Housing Trust. I'm with Renew Missouri.
Thank you very much. And is there other counsel present as well for Renew Missouri, or are you representing National Housing Trust and Renew Missouri?
Good morning, Judge. This is Tim Opitz, and I'm representing Renew Missouri in this case.
Okay, and I'm looking for Mr. Opitz. I didn't see a video yet. I can't tell if you're on video or not.
I am on video.
Oh, now I see you. Thank you.
Thank you, Judge.
All right, so then who do we have here to enter an appearance for Sierra Club?
Hi, this is Kristen Henry, and my address is on record. And we also have Henry Robertson with us as well. And his address is on record as well.
Thank you very much. And I think, Mr. Robertson, you were appearing by phone. Is that right, sir? Ms. Henry, do you know if Mr. Robertson is actually here with us and might be having a technical problem or not?
I heard him identify himself on the phone earlier, and I didn't see his name appear, so I'm not sure if he's still with us.
Okay, so I'm going to give Mr. Robertson another chance to figure out if he's muted or for some other reason is not able to actually identify himself and enter an appearance today. Okay, I did hear his voice earlier as well, so we'll see if we hear from Mr. Robertson again.
Thank you.
Okay, and then for Spire, Missouri, oh no, I'm sorry, they're excused, so that's it for appearances today. All right, so as everyone knows, this hearing is being conducted by video and telephone conference. Among legal counsel, those of you who are able to appear by video, most of you have done so. I appreciate that. In general, attorneys should remain present by video. Of course, you may have a personal situation that arises that requires you to cut your video feed briefly, and you should feel free to do that. perhaps to shoo a cat off your desk or whatever else you might need to do. As for witnesses, witnesses are not expected to remain visible by video for the duration of the hearing. Instead, witnesses can connect their video when they take the stand, so to speak, and give their testimony, and then they can disconnect video after that. I'd ask everyone, to the extent that you can, please silence your cell phone and all the alerts you might have set up on your computer and other tech today, just to avoid those interruptions. Please try to keep your line on mute unless you're speaking. That will allow us to have a much clearer line of communication today. The chat function in this program is a public only. You can't do private chats. The only reason anyone should be using the chat is maybe as a backup to let me know if they're having some kind of technical problem and they have no other way of communicating with me. So I will be looking at that, but it's probably not the most direct route to communicate, and just be aware that those chats are not part of the record of this proceeding and that they are public and available to everybody. The audio from this hearing is also being broadcast via web stream from the Commission's website. So in general, I'm going to try to break every 2 hours. This morning, we need to break no later than 11:45 a.m. because the Commission has a weekly agenda meeting and graciously rescheduled that to noon for us. So we will have to make sure that we are done by 11:45 this morning. Please feel free to speak up and let me know if you need a break. All right, so the parties have generally identified all the documents that they anticipate offering on the record and are going to use at this hearing. However, I think OPC was having a technical problem, so at some point we might get around to discussing with them what their status is. I haven't had a chance to check. No, it doesn't look like I don't have anything in email right now clarifying whether they were able to distribute exhibits. So the last message I'd had from OPC was that there was an email problem. So we did have an exhibit list, but I don't know if we actually had pre-marked exhibits.
Judge, my understanding is that, Judge, this is Caleb Hall from OPC. My understanding is that separate emails were sent after my technical issues from our office assistant, and all those exhibits should have gone out. Were you not included on those emails?
I don't have any email from OPC with exhibits attached.
Well, I have them available now to send out to the parties. The larger issue that I've discovered is that the PSC and OPC are on separate email servers, despite both being within the same department. And so I cannot send any file larger than 50,000 kilobytes out to anyone outside of our office.
So I think there's an easy way that we can deal with this. If you can make filings in EFIS, which you clearly can, you could distribute your proposed exhibits by filing them in EFIS. And that should avoid that problem. Do you think that would work?
I think that is definitely one solution. I believe, based on the documents and review of what we plan to offer at hearing today, I believe most, if anything, we can offer will be we can readily present via email. The larger files are copies of OPC testimony that's already been pre-filed.
Right, and actually, technically speaking, under the orders in this case, it wasn't necessary for all of those to be attached. So if you just identify that for everyone and everyone knows that it's your pre-filed testimony that you're going to offer as OPC exhibit number, whatever, then I think that covers it as far as I'm concerned. If parties have other concerns about that, they can speak up. So
Understood, Judge. At this moment, I didn't get clarification. I didn't get clarification from the court reporter if she also would require those exhibits then.
Yeah, we haven't addressed that with the court reporter.
Okay, I'll wait for that.
Yeah. So, but where are we with the email that already did go out that had some pre-marked exhibits? Because I went through and tried to see if you had OPC was offering some materials that actually are not already filed in this case in some form. And there were some things I wasn't able to find. So are those going to be provided to me so that I can also provide them to the commission?
Yes,
to be prepared.
Okay. Yes, I can do that right now.
So it sounds like what happened was that information was shared among the parties, which is excellent, but I just wasn't included on those.
I believe that is what happened.
Okay. All right. So it sounds like this is going to be easy to resolve. So that's great. All right, so I think the next thing maybe to discuss with exhibits is to talk to Ms. Bench about whether it's useful to her to receive all the exhibits or not. So my understanding is that the court reporter takes the exhibits and essentially marks them and then passes them on to the commission. And what we're doing in this proceeding is marking them essentially electronically, and then the commission will file them. So I don't know if Ms. Bench is comfortable speaking up right now when we're on the record, but that's where we are. So did you have anything you want to tell us, Ms. Bench?
Just up there and see if Brian is there. I hope it's not us. Try it now, Rob. Hello? Hello?
I think what we're going to do is when we get to if we get to the point where we feel like we have to distribute additional exhibits, we will just at the break or whatever, I will try to talk to Ms. Bench about whether it's necessary to include her. Okay, so we're going to move on.
Judge?
Yes.
Can you hear me? This is Rob Hack for Evergy.
Yes, I can.
Okay, thank you. I've shown as muted, and I have one question for you, or one notification to you and the parties. There may be one exhibit that we will propose to offer that hasn't been identified to the parties yet. We identified that late after we had sent those exhibits out, and I just wanted to alert you to that.
Okay, so I appreciate the fact that it looks like someone put some effort into assembling a distribution list of some kind. So it looks like we should be able to pretty easily distribute documents to people who need to see them. So hopefully we'll have a very minimal number of not yet identified documents to handle that way. But it looks like we're prepared to do that. So I think that's fine.
Thank you.
Okay, all right. So we're going to follow the order of opening statements and the order of witnesses and cross-examination proposed by the parties on October 23rd. However, I do have one adjustment that I'd like to suggest. And it's my understanding that Mr. Greg Meyer, who is the only witness for Missouri Industrial Energy Consumers and Midwest Energy Consumers Group, needs to appear today. Is that correct, Mr. Woodsmall or Ms. Plesha?
I talked to Greg Meyer last night, and he has cleared his conflict, so we can take him in whichever order you prefer.
Okay, so he no longer needs to appear today.
Correct.
Okay. All right, so then we can just proceed as the parties had proposed. And then we do also have a concern with Mr. Casely. My understanding is that Mr. Casely, a witness for Evergy, is available only this morning. Is that correct, Mr. Fisher or Mr. Hack?
That is correct. I know he's available this morning. What I don't know for certain is if he could be available after this morning.
Okay, so I think what I was hoping we would do is just make sure that we hear from him this morning. And by this morning, that means before 11:45. Is that
perfect?
Okay.
I believe he's listed as our first witness, Judge.
Yes. Okay. So those were all the preliminaries that I wanted to discuss before we get into opening statements. The other thing I would note about that is that because we have a witness that we need to hear from before we break for agenda, I would propose that questioning of counsel after opening statements would be deferred until after all opening statements have been made. That will give us a chance to assess how much time we have for Mr. Casely's testimony. I wouldn't think that would cause any severe problems for counsel, as it's really just a convenience for the commission to be able to ask those questions right away. But that's the procedure that I'm going to propose that we use to make sure we have time for Mr. Casely. So does anybody have any comment on that or any additional preliminary matters to discuss before we move on to opening statements?
Judge, this is Commissioner Holzman. I just wanted to check in.
Oh, good. Thank you for letting us know that you are here, Commissioner Holzman. I didn't catch whether you have video today or what line you're on. Do you want to speak up one more time
just
for
audio.
me? Okay, I
Just
think
audio.
I see which one you are, so I'm going to rename that so I know your line and I know when you're present. Thank you.
Thank you.
All right. So let me just send a quick message here to let everyone know we're going to be starting with opening statements, and then did any of the parties have any preliminaries? I don't see anybody who looks like they have anything they need to say. Okay, so looks like we can get started with opening statements. And we would start with Evergy. I believe that's Mr. Fisher. And there is a presentation that is on the screen that was teed up.
Thank you, Judge. May it please the commission. My name's Jim Fisher, speaking today on behalf of the applicants in this case. Although the first issue on the list of issues is a question of whether the COVID-19 pandemic is an extraordinary event, I think we've all experienced personally the extraordinary times of 2020. We've all experienced the stay-at-home orders and the shelter-in-place orders. And of course, such orders have applied to Evergy's employees as well as its customers. Many of Evergy's employees, including our witnesses in this case, have been working from home for months. We've all experienced closed businesses, including restaurants, theaters, churches, and most every non-essential business. We've all experienced the early closing of schools, colleges, and universities, and more recently, schools going virtual or a combination of in-person and online classes. Perhaps most importantly, we've all heard the daily news reports of thousands of new COVID-19 cases and over 240,000 tragic deaths from the virus in the United States. And many of us have friends and family that have been adversely affected by this contagious virus. It has been an extraordinary and unprecedented time for Evergy, its customers, its employees, our state, our country, and for that matter, even our planet. And as I'll discuss in a moment, many of the parties to this case, including the staff of the commission, MIECG, or MIEC, MECG, and the Sierra Club, as well as the company, have recognized the extraordinary nature of the pandemic and have entered into a non-unanimous stipulation and agreement which recommends a resolution of the issues in this case. Several other parties, including Ameren, Spire, and Missouri American Water Company, have indicated that they don't oppose the resolution of the case on the basis of this stipulation. Public Counsel and the National Housing Trust have filed pleadings opposing the stipulation. Public Counsel has asserted in this case that the pandemic is not an extraordinary event for Evergy and is opposing the stipulation and agreement. For the reasons that are quite apparent to anyone that's lived through 2020 and the testimony in this case, this position should be rejected. In response to these extraordinary times, Evergy has adopted a comprehensive COVID-19 customer response plan that we have fully developed and communicated to assist customers during these extraordinary times. As Chuck Caisley explains in his testimony, Evergy has been an industry leader in our response to customers' needs during the pandemic. The company was one of the first public utilities to announce a voluntary moratorium on disconnections of service for non-payment. That moratorium included waiving all charges, fees, and deposits typically associated with non-payment or late payment of bills. The company has continued to lead in development of alternative payment arrangement plans, including being one of only a handful of investor-owned utilities in the United States that offered incentive programs offering bill credits for customers who made payment arrangements during the pandemic. The company has also provided additional support to help the customers in our communities to recover from the impact of COVID-19 pandemic effects, including a pledge of $2.2 million in contributions to help agencies, communities, and customers. Included in this support is $400,000 already pledged for Evergy emergency grants to help nonprofit agencies on the front lines that have remained open and are delivering essential services. Also included is $800,000 in grants to nonprofit agencies for Evergy's Hometown Economic Recovery Program that will help build back our local economies by supporting small businesses and entrepreneurial efforts, business attraction and retention, and workforce training and development. In addition, Evergy has announced that it is committing up to $1 million to Dollar Aid, Project Deserve, and other programs that assist customers with energy bill payments. These contributions are being recorded below the line, and the company will not seek to recover them in rates. These actions, in combination with Evergy's customer communication and outreach, has reduced net residential arrearages below the pre-COVID-19 levels by the end of August. Although the government restrictions have been relaxed since the first stay-at-home and related orders were issued, we don't know how long the pandemic will last. But we all know, and we will never forget, the events of 2020 as extraordinary and virtually unprecedented in our times. In this proceeding, Evergy requests that the Commission approve its application for an accounting authority order permitting Evergy to accumulate and defer to a regulatory asset the extraordinary costs and financial impacts as a result of the COVID-19 pandemic, as modified by the non-unanimous stipulation and agreement filed on October 8th, 2020. Now, under the terms of the stipulation, the Commission will have the opportunity to consider the costs and financial impacts for possible recovery in Evergy's next rate case, which is planned to be filed in early January of 2022. When the Commission reviews the testimony in this proceeding, the Commission will find a substantial amount of agreement about what costs should be deferred for consideration in the next rate case. This slide is included in the surrebuttal testimony of Darren Ives. It shows that the company staff, MEIC, and MECG agree that the Commission should authorize deferrals of certain pandemic-related costs. The company staff, the Missouri Industrial Energy Consumers, the Midwest Energy Consumers Group, and the Sierra Club joined in the non-unanimous stipulation that I mentioned that was filed in October of 2020. I'd like to briefly summarize the main provisions of the stipulation, and then I'll address your questions about it at the appropriate time, Judge. Paragraph 2 of the stipulation lists the incremental costs caused by the COVID pandemic that would be tracked and deferred into a regulatory asset beginning March 1st of 2020. These costs include newer incremental operating and maintenance costs related to protecting employees and customers, including cleaning costs and personal protective equipment, technology upgrades, which include equipment directly related to enabling employees to work from home and associated contract labor, employee sequestration preparation costs, bad debt expense due to COVID-19 to the extent the total bad debt expense exceeds levels included in the cost of service of the last rate case. Costs related to any assistance programs implemented to aid customers with payments of electric bills during the pandemic, except for those programs that I just recently mentioned that are being paid for by Evergy shareholders, and waived late payment and reconnection fees. Paragraph 3 is an agreement to track all costs separately for Evergy Missouri Metro and Evergy Missouri West. Paragraph 4 quantifies the bad debt expense, late payment, and reconnection fees from the last rate case. Paragraph 5 states the agreement of the parties to defer the issue of carrying costs to the next rate case. Paragraph 6 states the company's agreement not to defer to a regulatory asset any lost revenues from reduced customer usage during the pandemic. Paragraph 7 lists operating cost reductions that will be tracked and netted against the deferred costs. Paragraph 8 discusses the duration of the accounting authority order, which will be until March 31st, 2021, unless it's extended, renewed, or terminated upon agreement of the signatories in the commission, or approved by the commission if brought to the commission by a signatory party if all the signatories do not agree. There are also provisions related to the treatment of the deferral of uncollectible expense, which will end on September 30, 2021. If actual net write-offs exceed the uncollectible expense in the last rate case on a quarterly basis by at least 10%, then the excess amounts above the rate case level would be deferred. If the actual net write-offs, on the other hand, turn out to be less than the amount in the last rate case by 10% or more, the difference will be used to offset any uncollectible expense recorded to a regulatory asset. Paragraph 9 includes provisions related to the information that will be filed with the commission related to the pandemic. And now then, skipping to paragraph 16, the company agrees to evaluate the advisability of extending its COVID-19 customer arrearage payment plan beyond December 31st, 2020, and its cold weather rule payment plans beyond March 31st of 2021, in consultation with staff, Public Counsel, and the National Housing Trust. Now, there is a typo in the last sentence of that paragraph. The stipulation states that the company also agrees to evaluate the advisability of offering additional customer assistance programs after December 31st of 2021. That date should be December 31st of 2020. And I think all the parties are agreeable to that. I'm getting quite a bit of feedback. I don't know if somebody can mute their line. Okay, thank you. In paragraph 18, the company agrees that it will continue the practices currently in place of waiving late payment fees and not undertaking full credit external reporting of its customers for the duration of the approved AAO for pandemic-related incremental costs and cost reductions. I think the remaining provisions of the stipulation largely discuss the mechanics of the agreement and specify that the signatories reserve the right to review and challenge the company's recovery of COVID-19 costs in the company's next general rate case. Judge, we would respectfully request that the commission approve the non-unanimous stipulation and agreement, which is a joint recommendation of the company, staff, MIEC, MECG, and the Sierra Club. Now, the Office of the Public Counsel opposed the deferral of COVID-related costs in their testimony on the theory that the COVID-19 pandemic is not an extraordinary event for Evergy under the Uniform System of Accounts. For all the reasons that I've previously mentioned, the Commission should find the pandemic is an extraordinary event for the company and its customers. The Public Counsel also raised the topic of General Instruction Number 7, related to the accounting of extraordinary events or extraordinary items on a company's income statement. While this instruction applies to the accounting of extraordinary items on the income statement, it has nothing to do with the balance sheet presentation or the determination of whether costs may be deferred into a regulatory asset or a regulatory liability. Those terms, regulatory asset or regulatory liability, are not even mentioned in General Instruction Number 7. Based upon our research, it appears that Missouri is the only state that has relied on General Instruction Number 7 in any AAO case. We recognize that the Commission does have the broad discretion to evaluate the facts and the circumstances presented in determining the appropriateness of deferral treatment. And Darren Ives discusses this issue at some length in his testimony. based upon his understanding of the USOA as a CPA, and his opinion has been confirmed by the two largest independent accounting firms and the accounting staff at the FERC. As Mr. Hives explains, Evergy believes that the Commission has the broad discretion to authorize the deferral of costs and financial impacts without being limited by General Instruction Number 7. Assertion by parties that the USOA General Instruction Number 7 criteria must be met to authorize deferral of treatment are just simply not correct. In fact, this Commission has demonstrated in numerous cases that they may authorize deferral treatment for costs without referencing or relying upon that general instruction. The Public Counsel has also discussed the 5% materiality standard in General Instruction Number 7. As I've already explained, Public Counsel's reliance upon that general instruction is misplaced. But more importantly, the Commission has also previously ruled that materiality is not case dispositive. Certainly, the Commission has often in the past authorized deferral of costs that did not reach that 5% of income level. For example, the Commission has authorized AAOs and trackers associated with changes to the cold weather rule, the electric vehicle charging costs, green tariff program costs, lead service line replacement costs, Y2K costs, ice storm costs, security costs, and numerous other occasions where the level of cost did not reach the 5% of income level. In any event, as Staff Witness Bolin recognizes on page 6 of her rebuttal testimony, we don't know how long the pandemic will last, and we don't know the full extent of costs and financial impacts at this time. And recently, the Commission has already authorized similar AAOs for Spire and Missouri American Water Company. The Public Counsel has also made several customer-specific recommendations related to waiving disconnection and reconnection fees, expanding payment plans, and matching programs for bad debts. We believe these items have been adequately addressed by the company's COVID-19 customer response plan and its shareholder-funded customer programs, and they're outside the appropriate scope of this AAO proceeding. Turning to the National Housing Trust, the National Housing Trust witness Roger Colton did not specifically address these COVID-related costs in his testimony. Instead, he focused on customer issues which we believe are adequately addressed by the company's COVID-19 customer response program and are outside the scope of this proceeding. Public Counsel witness Mark supported the expansion of those customer programs, but only on the condition that the company's shareholders pay for the expansion. The company disagrees with that proposal. So in closing, I'd be happy to take your questions at the end whenever it's appropriate, and thank you very much for your attention today.
Thank you very much, Mr. Fisher. Because it is 9:43, we've got a couple hours to get testimony taken care of for Mr. Casely and the other opening statements. I'm going to have us proceed to the next opening statement before any questions are given to you. So let's proceed with staff's opening statement. Thank you.
Well, thank you, Judge, and may it please the Commission. My name is Jamie Myers, and I represent the staff of the Commission in this matter. First, staff filed rebuttal and surrebuttal testimony in this matter, and ultimately, after negotiation amongst the parties, staff became a signatory along with Evergy, MIEC, MECG, and Sierra Club to a non-unanimous stipulation and agreement filed on October 8th of 2020. Staff believes the terms of the non-unanimous stipulation and agreement are reasonable and consistent with the public interest, and staff recommends the Commission issue an order consistent with the terms of the non-unanimous stipulation and agreement that authorizes Evergy to track and defer into a regulatory asset incremental costs directly related to the COVID-19 pandemic beginning March 1 of 2020. These specific costs are in paragraph 2 of the non-unanimous stipulation and agreement. Additionally, and I know Mr. Fisher just walked through the stipulation and agreement, but just to reiterate, staff would also recommend the Commission's order authorizing Evergy to track and defer certain COVID financial impacts, as Mr. Fisher described, also include the terms in the non-unanimous stipulation agreement related to carrying costs found in paragraph 5, lost revenues in paragraph 6, savings to be deferred that's addressed in paragraph 7, duration of the AAO, which is in paragraph 8, reporting of information, which is in paragraph 9, accounting practices and procedures in paragraph 13, future recovery addressed in paragraph 14, arrearage payment plan commitments in paragraph 16, customer protections in paragraph 18, and the other paragraphs which I've not specifically listed that are contained in the non-unanimous stipulation agreement. Now, staff does not recommend the commission order include the recommendations made by OPC and NHT that were not included in the non-unanimous stipulation agreement. The additional recommendations not included in the non-unanimous stipulation agreement, as Mr. Fisher noted, are beyond the scope of what is considered in an AAO application. And staff would direct the Commission's attention to case number EO-2020-0383 for information on COVID-19 programs that Evergy is offering its customers. Additionally, staff would direct the Commission to staff witness Natel Dietrich's testimony, her rebuttal testimony in this matter, where Ms. Dietrich states that many of the recommendations that have not been included in the non-unanimous stipulation and agreement are more appropriate for consideration in the docket the Commission opened to consider the best practices for recovery of past due utility customer payments after the COVID-19 pandemic emergency. That file number is AW-2020-0356. Now, Missouri courts have recognized the Commission's authority to authorize, in the form of an AAO, a utility to defer and capitalize certain expenses until the time it files its next rate case. While the courts have recognized the Commission's authority to authorize an AAO in extraordinary and unusual circumstances, there is nothing in Missouri law or Commission rule that limits the Commission to granting of an AAO to any particular set of circumstances. Thus, it is up to the Commission's discretion to determine if a set of circumstances is appropriate for the authorization of an AAO. Staff believes and would recommend the Commission find that the current COVID-19 global pandemic is an extraordinary event. It is unlike any event we have experienced in our lifetimes, as Mr. Fisher described. The pandemic is also unusual in nature, and that it is expected to continue to last for a number of months, unlike most events for which utilities request an AAO, which costs are incurred in a very limited time frame, such as an ice storm or a tornado. Lastly, it is important to note that while staff recommends the Commission issue an order consistent with the non-unanimous stipulation and agreement that allows, among other things, Evergy to defer certain costs and savings, an AAO is not a guarantee of recovery for the utility. In authorizing an AAO, the Commission is simply allowing for certain costs to be separately accounted for possible future recovery by Evergy. In Evergy's next general rate case, staff will look at any costs and savings Evergy is permitted to defer, and staff will make its recommendation in that future proceeding on what it believes is appropriate for Evergy to recover. Now, staff had 4 witnesses file testimony in this matter: Kimberly Bolin, Byron Murray, Robin Clethermus, and Natel Dietrich. All 4 of staff's witnesses are present today, and like me, we are all available to answer questions at the appropriate time. Thank you.
Thank you very much, Ms. Myers. I'm going to note now that you've referred to EO 2020-0383 and AW 2020-0356. And I would propose that the Commission would take official notice of those cases. Does any party object to that? Okay, so the Commission will take official notice of the cases referenced by Ms. Myers in her opening, and we can proceed now to hear from Sierra Club. Thank you.
Thank you, Your Honor. May it please the Commission, my name is Kristen Henry, and I represent Sierra Club in this matter. Evergy requested authorization from the Commission to create an accounting authority order, or an AAO, for 8 different types of costs or lost revenue. These costs and lost revenues are listed as issue number 3 with 9 sub-issues. These requests actually fall into 4 distinct categories. The first is for costs directly related to the COVID-19 pandemic. The second are revenues that Evergy earned but didn't collect because of the pandemic. The The third is for lost or unearned revenue because of volumetric sale changes associated with the pandemic. And finally, a catch-all request for any other costs or expenses. Sierra Club submitted expert testimony of Cheryl Roberto with regard to Evergy's request to create an AAO for lost or unearned revenue because of volumetric sale changes associated with the pandemic. Mrs. Roberto's testimony detailed many reasons why the Commission should not create an accounting authority order for lost or unearned revenue, including, first, the fact that unearned income does not qualify as a regulatory asset under the Uniform System of Accounts. While Evergy makes much in its application of the extraordinary nature of the COVID pandemic, the question of extraordinary only goes to whether the timing of an accounting claim can be moved to another reporting period. Evergy never addresses the threshold issue under the Uniform System of Accounts, which is whether unearned revenue is a recordable accounting item. Unlike the claims Evergy had made for its actual reasonable and prudently incurred cost related to the COVID-19 pandemic, selling electricity then expected to a commercial and industrial customer is not an incurred cost and would not otherwise be charged to an expense. Second, even if lost or unearned revenue resulting from lower than anticipated sales was a recordable accounting item pursuant to the Uniform System of Accounts, Evergy made no claim of net financial harm related to lost or unearned revenue to demonstrate the significance of the impact. Third, disappointing sales do not qualify for treatment as a regulatory asset under the governing accounting rules as applied in Missouri. Fourth, the balance of equities demonstrates that the Commission should not allow deferred accounting for lost revenue. Fifth, Missouri regulation places the risk of volumetric electricity sales variation squarely with the utility. The Commission authorized Evergy's return on equity under circumstances that included this allocation of risk. If the risk had been allocated to customers, the Commission would have necessarily reduced the return on equity granted to Evergy to account for the reduction of risk to Evergy's investors. 6, best utility regulation practice is for Commission to recognize the distinction between expenses, foregone revenue, and unearned revenue. Commissions employing these best practices uniformly deny utility requests to create a regulatory asset for unearned or lost revenue due to COVID-19. On October 8, 2020, a non-unanimous stipulation and agreement was filed with the Commission. This stipulation and agreement was signed by Evergy, the staff of the Missouri Public Service Commission, Missouri Industrial Energy Consumers, Midwest Energy Consumer Group, and Sierra Club. The non-unanimous stipulation and agreement would allow Evergy to create an AAO for the first 2 categories of costs, which are expenses directly related to the COVID-19 pandemic and to earned but not collected revenue. Evergy would not get an AAO for the 3rd or the 4th category, which concerns lost revenue from reduced load and the catch-all category. This stipulation and agreement fully resolves the issue Sierra Club raised through its expert testimony, as it does not allow Evergy to create an AAO for lost or unearned revenue. In addition, this stipulation and agreement contains important consumer protections. For this reason, Sierra Club respectfully requests that the Commission approve the stipulation and the settlement agreement as filed.
Thank you very much, Ms. Henry. We can proceed now to hear from Missouri Industrial Energy Consumers, please.
Good morning. May it please the Commission. My name is Diana Plesha, and I represent the MIEC. I'm here today to support the non-unanimous stipulation and agreement, which has been summarized very well by the other counsel that have spoken before me. Of particular importance to MIEC in these negotiations was the issue of lost revenues. We feel that the stipulation strikes a balance between the interests of consumers and the utility, and that it's a forward-thinking stipulation that we think will resolve issues going forward for crucial issues for both the company and consumers. We believe that the commission should approve the non-unanimous stipulation. We do have in evidence in the record, or will have in evidence in the record, the rebuttal and surrebuttal testimony of Greg Meyer, and he will be available for questions from the commission as well as cross-examination by the parties that are contesting the stipulation. And if the commission doesn't have any questions, that would conclude my opening statement.
Thank you, Ms. Plesha. We may have commissioner questions for council on opening after all opening is done and when we make sure we can hear from Mr. Casely this morning. So there will be an opportunity for that. We can proceed now to Midwest Energy Consumers Group, please.
Good morning, Your Honor. David Woodsmall for the MECG. I'll be fairly brief. Evergene staff did a good job discussing the various provisions contained in the non-unanimous stipulation, so I won't go through all those provisions. Instead, I want to briefly discuss the law regarding the treatment of non-unanimous stipulations. Then I want to address the standard for issuance of an accounting authority order. Finally, I will address a couple of the more important provisions in the settlement. So non-unanimous stipulations. Missouri law and commission rules stated that if a settlement is unanimous, you can simply approve it if you want. You don't need evidence to support a unanimous settlement. That is what happened with Spire and the Missouri American settlements. Those settlements were not opposed. Therefore, you didn't need to conduct an evidentiary hearing and accept evidence. You were within your authority to simply approve those settlements. A non-unanimous stipulation, however, is a different issue. Commission rules provide that an opposed settlement simply represents the position of the supporting parties. You can't simply approve it. Instead, you must issue a report and order that contains findings of fact that are supported by competent and substantial evidence. That doesn't mean that the non-unanimous stipulation in this case is worthless. The signatories to that settlement maintain that given the pre-filed testimony in this case, as well as the evidence to be elicited during the hearing, you may issue an order with findings of fact that adopt each and every of the provisions of the settlement. MECG and the other signatories urge the commission to issue findings of fact that adopt all the provisions of the opposed settlement. So the law regarding AAOs, and this has been addressed some by Mr. Fisher. As you're each aware, Missouri courts in the Uniform System of Accounts provide that deferral accounting is only authorized where an event is extraordinary. The commission has held that an event is extraordinary if it is, quote, abnormal and significantly different from the ordinary and typical activities of the company, end quote. MECG agrees that the COVID pandemic is an extraordinary event. Much like a tornado, ice storm, or other act of God, the pandemic is significantly different from the typical operating conditions of the utility. As such, it is appropriate to defer certain costs arising out of the pandemic. I won't take a bunch of your time this morning discussing the terms of the settlement. You are largely familiar with the terms of the agreement. You have already approved settlements for Spire and Missouri American, which are very similar to the non-unanimous agreement in this case. The settlement provides for some very familiar components. Specifically, the settlement allows Evergy to defer the incremental safety costs incurred to address the pandemic. Additionally, the settlement allows Evergy to defer the increase in bad debt expense, as well as the shortfall in disconnection and reconnection revenues. These are virtually identical to the Spire and Missouri American settlements. Important to MECG and consistent with our testimony, the settlement expressly provides that Evergy will not defer any lost revenue resulting from reduced customer usage. Frankly, this was a drop-dead issue for MECG. In previous cases, the commission has rejected the deferral and recovery of lost revenues. In 2012, Missouri Gas Energy sought the deferral of lost revenues, and the commission rejected it. In 2014, Ameren sought the deferral of lost revenues, deferral and recovery of lost revenues associated with an ice storm that knocked out Noranda, and the commission rejected it there. Other commissions have similarly rejected it, including more recently the Indiana Commission. MECG believes the deferral of lost revenues should not be allowed, and the non-unanimous stipulation precludes such a deferral. One major difference between this settlement and the Spire and Missouri American settlements involves the bad debt extension mechanism. The Spire and Missouri American agreements simply state that Spire and Missouri American can seek to extend the agreement past the March 31, 2021 deferral period. While the Evergy agreement contains a similar provision, it also contains an objective test to determine whether the deferral of increased bad debt costs should continue. Specifically, the bad debts for a quarter are compared to the bad debts included in Evergy's rates. If actual bad debts are more or less than 10% above the amount included in rates, then the deferral will continue. And this extension can last for 2 quarters until September 30th, 2021. As mentioned, MECG is presenting the testimony of Greg Meyer. He'll be happy to address MECG's original positions in this case, as well as the reasonableness of each of the provisions in the stipulation. Thank you for your time.
Thank you very much. We can proceed now to hear the opening from the Office of the Public Counsel.
Good morning, and may it please the Commission. This is a case about accounting standards, and Evergy's request does not meet this Commission's applicable standards. Public Counsel already provided the reasons why Evergy's request does not meet the Commission's Accounting Authority Order, or AAO standard, in its position statement filed earlier in this docket, so I don't really want to belabor those points. Instead, I wish to talk about what this case is also about. Fairness. Evergy initially requested for the authority to defer COVID-19 related incremental costs and lost revenues to be considered for recovery in Evergy's next rate case. Evergy has since modified its position with the non-unanimous stipulation agreement before this Commission. This stipulation is similar to that agreed to with Spire, Missouri and Missouri American Water, but there are 2 notable exceptions. First, unlike Spire or American Water, Evergy is not coupling its COVID-19 AAO with any particular COVID-19 related customer program or other financial response. Spire agreed to implement an arrearage matching program, and American Water agreed to offer a bill credit for its customers above and beyond what it already had previously committed before it filed for its application. Evergy's agreement refers back to single and 4-month payment plans that were offered through this August and pre-existing customer protections offered by this Commission, such as the cold weather rule. The second exception is that Evergy's deferrals will go beyond March 31st of 2021. Evergy plans to defer all COVID-19 related incremental costs and savings till the end of March. Then afterwards, we have what is being referred to as a bad debt extension mechanism. I like to call it a gambling provision. From April 1st, 2021 to October, if quarterly bad debts are higher than what is accounted for in rates, then Evergy gets to defer the excess. Evergy's books will then reflect a world where that financial liability isn't happening. If quarterly bad debts are less than expected, customers win the gamble and get a credit. The problem with relying on gambling, though, is that the house always wins. We've all been affected by COVID-19 to varying degrees. Some have been inconvenienced, some have lost jobs, and some have lost loved ones. How has Evergy been affected? Seemingly not at all. The evidence Public Counsel provides at this hearing shows that Evergy is not altering its capital expenditure plans in light of COVID-19's economic impact. Evergy has not reduced its compensation or benefits for its personnel and upper management. And testimony from OPC witnesses Robert Schallenberg and Jeff Mark demonstrate that COVID-19 has not had a financially material impact on the company. Not necessarily its customers, but the company. Evergy's response to Public Counsel is not to dispute this, but to argue instead that they don't have to prove materiality. During this pandemic, Evergy has been releasing statements to the public telling them that when it comes to COVID, we are in this together. Are we? Seriously. Evergy is asking for an AAO so its books can reflect earnings that would have happened but for COVID-19. Evergy is asking for this treatment for an event that it argues is extraordinary, while also claiming that it doesn't need to prove financial materiality. Evergy is further asking for a gambling provision just in case things get worse after March. Is Evergy offering some sort of payment plan or a customer arrearage program to address the coming storm? No. To reiterate, Evergy's position is that it should be able to insulate its financial books with deferral accounting, that it's done enough for customers this past summer. And so everything's fine for the customers, but also customers may not be making their debt obligations after March. And so we need a separate tracker, a separate gambling. Evergy's inability to meet the deferral accounting standards of this commission is reason enough to reject the stipulation. But this gambling provision, this paragraph 8, is especially odious. Getting more protection from customers than other utilities in the state, while offering even less for customers, is unacceptable to public counsel. We ask that this commission think so too. The OPC offers the testimony of 3 witnesses over the course of this hearing. Robert Schallenberg is Public Counsel's Policy Director. He has testified before this commission numerous times on accounting authority order standards, and he can speak to why Evergy has not shown that it has met that standard. David Murray is testifying as a chartered financial analyst and utility regulatory manager for Public Counsel. He can speak to the equity risk premium that is already included in Evergy's rates and how Evergy's rates are set to already account for some amount of financial instability. Dr. Jeff Mark, Public Counsel's chief economist, echoes the findings of Mr. Schallenberg while offering his review of Evergy's response to COVID-19 and his recommendations on what payment plans or other protections the commission should consider when approaching this AAO. I invite you to ask questions of all these witnesses and other witnesses at this hearing. I will provide whatever answers I can to your questions following all opening statements. May otherwise defer to Public Counsel's witnesses. Thank you.
Thank you very much, Mr. Hall. We can proceed now to hear from the National Housing Trust.
Thank you, Judge, and may it please the commission. My name is Andrew Linares. I'm here representing the National Housing Trust today. This hearing is taking place at perhaps one of the most economically precarious moments in the memory of anyone living today. COVID-19 infections in Missouri and in the United States are at record highs. It appears Congress may not pass another COVID relief package, even as federal unemployment insurance begins to end for millions of Americans. So we're in for several months of increased unemployment, mounting utility debt, disconnections, evictions, and strain on social services. To date, the state of Missouri has not taken any action to assist Missouri utility customers, and this case presents an opportunity to address a mounting crisis for Evergy's most vulnerable customers, and at the same time to minimize Evergy's uncollectible expenses and bad debt related to COVID in order to protect ratepayers. Some parties argue that NHT's proposals in this case are inappropriate for an AAO case or are better raised elsewhere or are already met by existing programs. I want to respond to each one of those arguments, but first I'd like to briefly summarize the areas where NHT is asking for the commission to take action in this case. NHT's witness Roger Colton's rebuttal testimony includes several concerns. First, Mr. Colton begins by demonstrating how the pandemic is disproportionately impacting low-wage employees and residents of affordable housing. Most often, through no fault of their own, these customers are seeing their employment and their housing security vanish, along with their ability to pay their utility bills. This is particularly true of African Americans. Mr. Colton's testimony notes that African Americans make up roughly 11% of the Missouri population and suffer 33% of the state's COVID-related deaths. That was in August. In Mr. Colton's words, that population which has the least ability to respond to the economic catastrophe caused by COVID-19 is the same population that is being hit hardest with the public health and economic consequences. Next, Mr. Colton articulates several general principles that the Commission should articulate to govern utilities' future recovery of COVID-19 costs. These principles fit within the basic framework of Chapters 386 and 393 in the Missouri law, in which utilities have a statutory obligation to provide just and reasonable rates, and the Commission has a similar duty to only authorize rate changes that are just and reasonable. The first principle Mr. Colton asks the Commission to consider is that Evergy has an obligation to provide service within a least cost framework. And this is really the heart of NHT's case. The question is whether Evergy can make certain investments in customer programs, in resources, or in policies that will result in a more efficient, more cost-effective response to the COVID-19 non-payment problems, which its customers are facing. And in so doing, whether they can mitigate the costs that will arise if it fails to make such investments. NHT believes that without further attempts to mitigate customer arrearages, Evergy may accrue uncollectible debts that it otherwise may not have, thus increasing the costs that it can recover through an AAO resulting from this case. There are other principles that Mr. Colton addresses, including that Evergy should undertake reasonable actions to mitigate the harms of COVID-19, including the inability to pay, and that Evergy should operate in an efficient manner in both its collections and its expenses needed to make those collections. I won't get into those remaining principles. I want to transition into the specific proactive steps that Mr. Colton recommends Evergy take that could provide a path for Evergy to reduce costs relative to alternative approaches. And NHT, in this case, is requesting that the Commission only approve an AAO on the condition that Evergy address some of these steps. The first is to create a best practice arrearage management program through which customers can earn credits to retire arrears over a 12-month period. We recommend eligibility set at 200% of the federal poverty level, with allowances for longer-term deferred payment plans. The Office of Public Counsel just detailed the settlement in the Spire case, including the matching framework between ratepayers and Evergy shareholders, and NHT supports that framework. The second step in Mr. Colton's testimony that he recommends is expanding Evergy's economic relief pilot program by targeting relief to the extreme poor and by using what we're calling express lane eligibility and various community outreach strategies to make the program widely utilized and widely known across the most vulnerable populations. Mr. Colton also recommends to expedite the spending of all approved income eligible energy efficiency funds by targeting customers in extreme arrears and increase contributions to weatherization service providers. We are not calling for additional energy efficiency funds, save perhaps increased weatherization contributions. We are calling for the expedition of existing approved energy efficiency funds, given that they can address customer arrears. Finally, Mr. Colton recommends renewing a moratorium on disconnections for non-payment, suspension of late fees, and similar steps to assist customers through this unprecedented crisis. So NHT views the non-unanimous stipulation in this case as unacceptable, as it does not address any of these steps to limit customer arrears due to COVID-19. As far as NHT's positions on the ability to recover certain costs, we agree with the provision limiting the recovery of so-called lost revenues, and we do join the Office of Public Counsel in opposing provisions 8A and B regarding, as counsel for OPC was explaining, regarding higher than expected uncollectible expenses, or the so-called gambling provisions that he referenced. Okay, next I would like to address various arguments regarding NHT's testimony and recommendations in this case. The first being that these proposals I've just outlined, they don't belong in an AAO case, or they're appropriate somewhere else. Witness for staff, Ms. Natal Dietrich, argues that while NHT and OPC may provide a lot of good information on the effects of COVID-19 on vulnerable populations and perhaps some best practice ways to respond, nevertheless, these recommendations are outside the scope of an AAO docket. As I stated previously, we believe it's reasonable to insist that Evergy demonstrate its actions are leading to the least costs incurred if it wants broad recovery of these COVID-related costs. Commission is within its rights to order Evergy to implement customer programs and take steps to minimize customer debt during the pandemic. We believe our recommendations are intended to minimize the very costs to be recovered as a result of this case. So we disagree they're outside the scope. Ms. Dietrich suggests several other cases where these recommendations may be more appropriate. And just as an initial observation, all parties to the unanimous stipulation in Spire's AAO case have, of course, indicated their approval to addressing many of these concerns by signing to that stipulation, and that includes staff. One of the cases Ms. Dietrich raises is Evergy's application for approval of COVID-19 customer programs, or EO 2020-0383. It's worth noting that Evergy filed for approval of its programs on May 22nd, requested and received a waiver of the 60-day notice provision, and they received expedited approval a mere 6 days later on May 28th. So we obviously agree on the need for expedited action in response to this pandemic, but it did leave stakeholders with no opportunity for intervention or input. In this case, is really the first chance stakeholders in Evergy have had to obtain an order in response to the pandemic. And the situation is even more critical now than it was last spring or summer, and it will only become more so throughout the winter. Another case related here is the Pandemic Workshop Docket, or AW 2020-0356. I believe that's right. The Commission opened this docket in May, and NHT has contributed extensive comments during the summer as part of the Energy Efficiency for All Coalition's comments. There's been no commission order or direction resulting from this workshop to provide relief for disconnected customers or customers in severe arrears due to unemployment from COVID-19. So this workshop may be a place to arrive at a shared approach to electric, gas, and water utilities regarding arrearage management and disconnections and payment plans and things like that. However, such a process may take months and would very likely still require individual cases with each utility. A more direct route, we believe, is to place conditions on the approval of Evergy's AAO, in this case, in order to protect customers against some of the worst effects of the pandemic on their utility bills. One other argument that's been offered is that Evergy already offers COVID response programs and payment plans, and the company points to its existing payment plans, customer programs which total $2.2 million in company funds for COVID relief. I'd like to note that these existing funds are split between Kansas and Missouri, of course, and a significant portion of these funds consist of grants to small businesses and local nonprofits. Only a small minority of these funds are going toward bill assistance for Evergy residential customers in Missouri, which is where the primary strain of this pandemic is being seen. The fact is that Evergy's current program offerings fall well short of its peer utilities in the Midwest. The current crisis last spring led utilities all across the country and the Midwest to make unprecedented commitments to provide bill assistance and debt forgiveness for customers, suspend disconnections, late fees, and take various other actions to limit the accrual of uncollectible debts as a result of the pandemic. For example, Minnesota, their largest utility, Xcel Energy, They proposed a $17.5 million bill credit program for its most indebted customers. Illinois' Commonwealth Edison, or ComEd, reached an agreement with parties last summer for a COVID-19 bill assistance program worth $18 million in funding, including partial arrearage forgiveness. DTE in Michigan, the big utility in Michigan, pledged $13 million to help customers struggling with COVID pandemic, including direct relief for customers with high arrears. And notice all of these programs are targeted to high arrear customers to deal with the arrearage issue, which is essentially uncollectible debt in some significant degree. And of course, Spire, Missouri's largest gas utility, signed an agreement with advocates that includes a long-term deferred payment plan option, an arrearage management program paid for by both utility shareholders and ratepayers. And this, of course, occurred in the context of an AAO case. So just to sum up here, I'd just like to reiterate that we are facing a very serious crisis for Evergy customers in the coming months. Of course, this applies to all electric service customers in the United States. And Missouri is no exception, or perhaps above the average there. The unanimous stipulation in this case fails to include any additional bill assistance, arrearage management program, payment plan, debt forgiveness, or other steps to protect customers from the results of unemployment, from the economic hardships coming from this pandemic. So this failure to commit funds towards an arrearage management program or similar steps will not only leave Evergy's customers exposed during this crucial emergency, but it may lead to accrual of huge amounts of uncollectible debt, which may needlessly fall on the backs of ratepayers. And I don't believe Evergy has met its burden there of proving that its lack of addressing these programs will not lead to that scenario. So we would urge the Commission to take this opportunity to place conditions on the approval of Evergy's requested AAO. I encourage you to further review NHT's position statement and Mr. Colton's rebuttal testimony in this case, to ask whatever questions you might have of Mr. Colton when I tender him as a witness. And I'm happy to make myself available for your questions as well, although we may be doing that later. So thank you.
Thank you very much, Mr. Linares. We're ready to hear from Renew Missouri.
Thank you, Judge. May it please the Commission. I'll be very brief. Renew Missouri did not object to this stipulation agreement, but we also did not sign. Our position is that this stipulation does not rise to meet the magnitude of the moment we're in the times of COVID. I believe that the Commission has the ability to attach specific conditions that were recommended by Office of Public Counsel's witness, Dr. Jeff Mark, and NHT's witness, Mr. Roger Colton. And particularly those are appropriate when they are addressing circumstances that were the direct result of the very same event that the company is seeking to recover its own expenditures for. As for the specific details of the conditions, the customer specific recommendations of Office of Public Counsel's Dr. Mark and those of Mr. Colton from NHT, Renew Missouri believes would be appropriate to attach. And with those attached, we would support an order granting the AAO. That's all I have. Thank you.
Thank you very much. So we're at 10:24, and I would like to hear from Evergy about how long you would estimate in your experience Mr. Casely's testimony is likely to take. Let me make sure that Evergy's conference room is unmuted if Mr. Hack wants to speak up. Or perhaps Mr. Fisher is able to advise. I don't know.
We will just be taking cross-examination for the most part of Mr. Casely, so I don't think I can estimate how long that would take, but he's available right now. I see him on the screen, so we could go forward with it.
Okay, so parties.
Rob,
Those of
you're
you
on mute, I think. We can't hear you, Rob Hack. We still can't hear you.
So the system tells me that when I click your line, it says I can request unmute. So I've apparently sent a request to your system to unmute you. So that's something you have to do on your end. And while they try to figure that out, parties who will be cross-examining Mr. Casely, in your experience, how long do you think this is going to take? I'm just trying to figure out if we should be proceeding with that right now. It seems to me that's a good idea. So if anyone doesn't think so, speak up.
For MIEC, we will not have any cross-examination for Mr. Casely.
This is Sierra Club. We have no cross-examination for Mr. Casely.
Renew Missouri has no cross-examination for Mr. Casely.
Staff will have limited cross for Mr. Casely. Will take probably less than 5 minutes.
Judge, this is Caleb Hall. Public counsel does have some limited cross for Mr. Casely. Based on other hearings we've had in the evidentiary room, I wouldn't be surprised if it just lasts an hour based on a back and forth. And of course, Evergy has a responsibility and an opportunity to respond to whatever cross questions come. Perhaps we can start with Mr. Casely. However, maybe that's depending on what commissioners may have questions as well. That may extend past the time that they may be absent for agenda.
Okay, so this is what I would say then. It sounds to me like, and I appreciate you giving me some guidance on this, Mr. Hall. So it sounds like we should proceed with Mr. Casely because we should be able to get that done before we have to break. And then we can come back and open up the floor and let the bench ask questions of all the attorneys that we just heard from in opening. So that's how I would propose to proceed. But right now we have to make sure we can hear from Mr. Hack. And I just got a chat message that says that they show that they are unmuted. And on my end, it shows that you're muted. And when I try to unmute you, I don't have authority to do that. So have you toggled your mute one time? And let's see what happens. You've done that. Okay, and this line that I'm seeing that I don't have sound from is an audio call that was dialed in. Is that right? So how about you disconnect that and call us back? Okay? Okay. So this is what I'm going to suggest. I'm going to give this 10 minutes to get worked out. So if anyone needs to excuse themselves, please be back here by 10:38. And in the meantime, I will try to work out whatever our audio connection is, and we'll start with Mr. Casely's testimony at 10:38 a.m. That gives Ms. Bench a brief break if she needs one.
Judge, it's Justin. I have the screen showing intermission at this point until 10:38.
Thank you very much. I appreciate being reminded of the existence of that stream. Thank you.
You're welcome. I know it's easy to forget.
It is.
Can you hear us now?
Yes, I can.
Oh, that is a relief.
Yes. Sometimes a restart is the only solution. So just speak up for me one more time so I can figure out exactly what line that is again.
Yes, this is Rob Hack for Evergy in Kansas City.
Okay, so we are in recess until 10:38. So we have 9 minutes. And then we will come back and I can see you, I can hear you. We will all reconvene with your witness, Mr. Casely.
Thank you.
And we are now off the record because we're in a break, but Beth Bench knows that.
Right around here. So why? There you go. We're helpless, Brian.
Well, it sounds like that they muted from that side, and for some reason it just wasn't
Your Honor, are we still off the record?
We are off the record at this time, yes.
This is Ms. Henry from Sierra Club. I was hoping that we could get Ms. Roberto on today, and if we have to take her out of order, if that would be possible. I have a conflict tomorrow. I have another proceeding, and the attorney who was going to cover the case, his audio and visual doesn't seem to be working today. So just to make sure there's no tech issues, I was hoping that
Okay, and you have one witness, so we could move that witness up before staff's witnesses started, depending on how things go today with Evergy's witnesses, unless staff has a concern about that.
No concern from staff.
Okay, so thanks for mentioning it. I think I'll bring it up again once we get on the record, and we'll discuss it a little bit more.
Oh, okay, thank you.
Okay, so it looks like it is now 10:38 a.m. We do have a court reporter, so let's get back on the record. So where we left off, we were getting ready to move into Evergy's first witness, Mr. Casely. And Mr. Hack, is everything okay on your end?
This is Rob Hack. Can you hear me?
Yes. Good, okay.
I'm prepared to begin whenever you desire.
Okay, I just want to confirm that I am seeing all the individuals we need here present with us. And it looks like we have everyone who is essential. Ms. Bench?
Can Mr. Hack turn up his volume at all?
You'll have to. I will speak up more. Is that better?
Yeah, just speak as loud as you can.
Okay. We'll see what we can do here. My technical skills are limited. So I will begin. State your name for the record, please, sir.
Charles A. Casely.
So we need to swear in a witness if we're going to present a witness. So Mr. Casely, please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth, sir?
I do.
Thank you very much. And you may now proceed, Mr. Hack.
Thank you. Mr. Casely, where do you work? By whom are you employed, and in what position?
I work for Evergy, and I am Evergy's Chief Customer Officer.
Sir, did you cause testimony to be prepared and filed in this proceeding? Sir, rebuttal testimony that has been marked as Exhibit 2 for the confidential version and Exhibit 3 for the public version of that testimony?
I did, yes.
Do you have any changes to that testimony at this time?
I do not know.
If I were to pose to you today the questions that are asked in that testimony, would your answers be substantially the same?
Other than updating potentially some of the numbers from when this was filed, yes, my answers would all be the same.
And are those answers true and correct to the best of your knowledge and belief?
Yes, they are.
Mr. Casely, I would also ask you to identify what has been marked as Exhibit 1.
Uh-huh.
Can you identify that, please?
Oh, yeah, sorry. It's the stipulation and agreement, I believe.
Thank you. And have you been made aware of a typographical error in the non-unanimous stipulation and agreement, Exhibit 1?
Yes. On page 8, paragraph 16, the words are written December 31st, 2021. On the last two lines of that paragraph, those should be replaced with the date December 31st, 2020.
Thank you, sir. Does Exhibit 1, the non-unanimous stipulation and agreement, as corrected, represent the outcome Evergy and you advocate in this proceeding?
Yes, absolutely. While we stand by our original filing and our testimony in this case, it is that stipulation and agreement is something that we approve of and would ask for the Commission's approval.
With that, I would offer Exhibits 2 and 3 into the evidentiary record, as well as Exhibit 1, and tender Mr. Casely for cross-examination.
Would there be any objection to Exhibit 1, which is the non-unanimous stipulation and agreement with the correction that has been noted? Hearing no objection to that exhibit, unless someone wants to interrupt me, Exhibit 1 will be admitted to the record. And then you have Exhibit 2C, which is confidential, and Exhibit 3 have also been offered. Any objection to those exhibits? Okay, those exhibits will be admitted to the record as I have not heard any objections. And then I believe we're ready for cross-examination. So we can proceed with staff if you have any cross-examination for Mr. Casely.
Yes, Judge, we do have a few. Good morning, Mr. Casely.
Good morning. How are you?
Good. My name is Jamie Myers. I'm with Staff Counsel, and I have just a few questions for you. So your counsel just asked you a question regarding Exhibit 1, which is the non-unanimous stipulation and agreement, correct?
That is correct.
You're familiar with that document?
I am familiar with the document.
And so does the non-unanimous stipulation and agreement put forward additional customer protections found in paragraphs 16 and 18 relative to the original filed positions of Evergy and staff?
Yes, it does.
And for what period of time does this non-unanimous stipulation and agreement call for Evergy to continue its current practice of waiving late payment fees, one of the customer protections, as well as not doing external credit reporting, another customer protection for residential and small business customers?
Through March 31st of 2021.
And is that consistent with the deferral period?
It is.
Stipulation agreement. Additionally, for what time period does the non-unanimous stipulation agreement call for Evergy to waive reconnect fees for residential and small business customers?
Again, that's through March 31st of 2021.
And when does the non-unanimous stipulation and agreement call for Evergy to evaluate the reasonableness of extending their current offering of 12-month payment plans, as well as offering additional customer assistance programs in consultation with staff, OPC, and NHT?
That would be the first of the year, but honestly, that's an ongoing thing. We continue and will continue to evaluate this and consult with staff, OPC, and other stakeholders as long as the pandemic continues.
Thank you. And just one last question. So in your opinion, is the adoption of these additional customer protections a reasonable outcome?
Yes, we do believe it is.
Thank you, Mr. Casely. I have no further questions.
Thank you. Do we have any cross-examination from Missouri Industrial Energy? I think actually Ms. Plesha said you would not. I think you're muted.
No questions, thank you.
Thank you very much. And then from Midwest Energy Consumers Group.
No questions, Your Honor.
Thank you very much. Does Sierra Club, I think many of you have told me you would not, so I understand there's no cross from Sierra Club for Mr. Casely.
That is correct, Your Honor.
Thank you. And Renew Missouri also didn't plan to have any?
That's correct, Judge.
Thank you. So that leaves Office of the Public Counsel to get started now with your cross, sir.
Thank you. Well, Mr. Casely, the problem with crossing towards the end is when I say this, it sounds trite, but I'm going to say it anyway. Good morning.
Good morning. How are you?
Pretty good. Mr. Casely, do you have a copy of your rebuttal testimony in front of you for this case? Could you please turn to pages 11 and 12 of your rebuttal?
Yes, sir.
On these pages, there's a Q&A that starts on page 11 that goes to page 12. That Q&A is referring to contributions that Evergy has pledged to agencies and communities that Evergy serves, correct?
That is correct.
This is the 2.2 million figure that your counsel, Mr. Fisher, mentioned in his opening, correct?
That is correct.
Is this for all of Evergy service territory?
It is, yes.
Both Kansas and Missouri?
That is correct.
Do you know the breakdown in those numbers?
I don't think there is a specific breakdown. I would imagine, though, that it will run pretty much along a pro rata share between the customers that we serve in each state.
Are you familiar with the Evergy? Or let me rephrase that question. Are you familiar with the program Project Deserved?
Project Deserve yes, I am.
Is that an Evergy program?
It is a Evergy program in Kansas, yes.
Well, that answers my next question. Is that offered in Missouri?
No. In Missouri, we use Dollar Aid.
Mr. Casely, there is a $400,000 figure mentioned on page 11. What program is that referring to?
So that would be our emergency economic grants, and those would be going to not-for-profit organizations dealing with the impacts of COVID-19 in our communities.
What are some of these nonprofit agencies that are included in that grant program?
I mean, it's really anybody who deals with food insecurity, housing, could be different types of utility assistance. And again, there are emergency grants that are, for agencies that have a focus area that's, related to the front line of dealing with some of the impacts of COVID-19.
Judge, at this time, I would like to refer to a document that actually wasn't pre-filed as an exhibit or pre-noted. At this time, I'd like to email you, opposing counsel, and opposing counsel that document before I send it to the witness. Is that all right?
Sure, please do.
Mr. Hack, can you let me know when you've received the document and you've had a chance to review it?
Sure. What is it?
Not so sure it's appropriate for me to identify it unless the witness disagrees, but this is a data request that Evergy provided to OPC in this docket.
I have not received anything quite yet, Mr. Hall. I don't know if I was supposed to yet, but I have not.
My outbox is indicating that I did send it to you, Judge.
So Caleb, did you send it to the entire list that I had provided, the entire email address list?
No, I sent this to.
Because I have somebody who was on that list who's helping me get the documents. I don't have my email address, my email list open, or my email open. That was the purpose of that list.
So I have received the email and I can quickly dispatch it to the parties as a forward, but I believe there were many additional people on that list that Mr. Hack had provided. So I do think it would be appropriate that we make sure everybody has a chance to see this. So I can forward to all parties right now, if that's helpful.
Anthony.
Yes, thank you, Judge.
Okay, let me do that right now. And then parties can distribute as is needed, okay? Here we go. sending an email is very easy unless 35 people are watching you do it. So I did forward that to the parties, and I'll let you all receive that while I forward it to some additional folks who need to see it as well. Just everyone will have a couple minutes here to check their email, and then we'll proceed.
Okay, forwarding it now. Okay.
Okay, I am ready to proceed. I don't know about the rest of you. Has everyone received what they needed to receive?
I have not yet, Your Honor. Should be printed shortly. You might tell Chuck it's coming from me, not Anthony, unless Anthony's doing it. So Chuck, Carl Zobrist sent you the document?
Yeah, I don't have it yet, though.
Mr. Casely, do you have your email up now? I can send it to you directly and CC your counsel.
That would be fine. My email is up, yes. All right, I just received it from Mr. Zobrist.
We are still waiting here in Kansas City. I'm sorry. Thought I could show it to you on my phone. It's a little scratch. Phone, so if you want, Chuck, if you can take a look at it.
I'm looking at it now.
Well, then I'll continue questioning then. I apologize for the delay. Mr. Casely, your counsel has been gracious enough to send you the document I want to ask you about. This is data request number 2027 in this docket. Do you agree with me that this was authenticated by Evergy's regulatory team with an email from a Brad Lutz on the third page of this document?
I only have 2 pages of the document, but I will stipulate to that. This looks familiar.
Thank you, Mr. Casely. Do you agree with me that the questions that Mr. Jeff Mark posited to Evergy was to please provide multiple examples of nonprofits that have qualified for grant assistance under Evergy's Hometown Economic Recovery Program?
Yes.
And this has 23 separate nonprofits or agencies that were examples provided by Evergy?
That is correct.
Mr. Casely, you had mentioned earlier in questioning that the Hometown Economic Recovery Program is giving assistance to agencies that are addressing bill arrearages or utility bill payments. Can you point to any of these examples of such agencies on this list?
I'm looking through it, and I believe, just to be clear, my answer was more expansive than that, and I said that it did deal with people, agencies that are dealing, first response, frontline response agencies dealing with a host of impacts from this. pandemic. So, and I'm sorry, could you repeat your question one more time as I'm just looking through this list?
Yeah, sure. Can you, which of these agencies on this example sheet provided by Evergy would be addressing bill arrearages or utility payments for customers?
If by that you mean direct assistance, meaning money that goes directly through them to a customer, I do not believe any of these directly would. However, there are several on there that are working with identifying at-risk communities that would have, or particular needs and issues around whether it's food or utility or other areas of impact.
Okay, and examples of that would be like, example number 2 is the Boys Grow program out of Kansas City, or number 8 is the Hispanic Economic Development Corporation.
Correct. Those would be a couple of examples.
But you agree with me, those do not give direct assistance to customers looking to pay utility bills?
No, I agree with you.
Same with example number 21, the St. Joseph Chamber of Commerce.
I agree with you on that, yes.
Thank you. I have no further questions.
Okay, we can proceed to any cross-examination from National Housing Trust.
Thank you, Judge. Some very brief cross. Good morning, Mr. Casely. Oh, I'm sorry.
Actually, I'm sorry. I don't want to proceed at this point because Mr. Hall, what are we doing with the document that we just passed around and distributed to everyone and talked to the witness about? Is that something that should be part of the record in this case?
OPC doesn't see a reason to offer it as an exhibit. I can if you would desire me to, but this was I mostly used it as an aid for Mr. Casely and I to have our conversation.
So what you were hoping to point out was there was a list of 23 programs and ask him whether any of them provided direct relief for arrearages.
Correct.
Okay, thank you very much. I apologize for interrupting, and now I will ask Mr. Linares to begin. Thank you.
Thank you. Morning, Mr. Casely.
Good morning.
Do you have your Sir rebuttal testimony in front of you for reference?
I do.
I apologize. I don't remember what exhibit number that is.
It's 2 private, 3 public.
Thank you. So page 4 of your Sir rebuttal testimony, you stated that Evergy faces an unknown risk of collection due to substantial customers in payment plans or something similar. Do you see that?
Do you have a line that you're referring to? Sorry, just trying to.
All right. I can find that for you. So starting on 15.
Gotcha.
Or 16 rather. Would you say that this risk of collection or unknown risk of collection, as you say in your testimony, would you say that risk has become more significant or less since you authored this testimony?
Depends on what you're describing as risk. What I can tell you is that from accounts that were in arrears or being eligible for disconnection, we feel very we've seen positive trends, meaning that we're below the level of accounts in arrears that we were experiencing since March 13th. Having said that, the total amount of the arrears plus balances has grown significantly over this time period and is significantly greater as a result of the 12-month payment plan principally than we would experience otherwise. So yes, I would say there is a significant amount of risk associated with that.
And you're in a management position at Evergy. Can you tell us whether Evergy expects this risk of uncollectible debt to be more severe in the coming months?
I would say that all really depends. I mean, we have been pleased that schools have started to reopen and that restaurants and commercial businesses are able to conduct business again, although some of them are at more limited capacities. So right now, we're kind of holding our own, I would say. What is concerning is with the spike of cases that have been reported and what may happen as we come into the wintertime. I think that bears watching and making sure that if we were to see another shutdown, whether it was localized or statewide or even national, which is being discussed now, that could obviously change the situation pretty dramatically.
I'd like to turn to page 6, and I'm looking at the answer starting on line 16.
Okay.
So you are summarizing here the goals Evergy hopes to achieve as part of its COVID-19 customer programs in case number EO 2020-0383.
Yep.
Would you be willing to read those goals for me?
Sure. Reducing the number of customers in arrears and the magnitude of customer arrearages. Accelerating the ability to interact with customers to establish payment plans. Reducing the number of phone calls made by customers to the contact center and associated wait times. Reducing the number of customer disconnections for non-payment associated truck rolls and other collection activity costs. And maintaining essential electric service to as many customers as possible, which assists in maintaining the continuity of revenue streams that support the continued provision of safe and reliable electric service.
Thank you. So given that these are the goals Evergy hopes to achieve with customer programs in response to the pandemic, can you tell me what the purpose is of pursuing these goals for Evergy, the business purpose?
Well, first, there was a significant concern when we initially announced the moratorium that, and particularly as we went into summer, that customers would develop significant balances and have difficulty paying them off, which is why we initiated, we actually enlisted Trove Analytics and McKinsey, and we did a lot of work to try and establish, if we could, who might be most at risk, and develop programs and a protocol to reach out to people ahead of reaching a crisis level to try and mitigate the number of people that, once we lifted the moratorium, would be at risk of disconnection. That's very disruptive to their life or their business. But also once, we didn't want to see a bow wave of those things hit all at the same time. And we wanted to do as much as we could to have customers get on a reasonable payment plan to keep them as current as possible. And then, of course, we did have some limited success with some payment programs we established that also gave credits. At the end of the day, really the business purpose was two or threefold. One, we want to keep as many customers on as possible. Two, we want to mitigate the amount of bad debt exposure for the company and for a proceeding like this. We wanted to make sure that we maintained or improved customer experience so that as people were dealing with the stress of the pandemic generally, we could mitigate as much as we could from a financial and just a worry aspect that folks were going to lose their electricity or their business as a result of that. And then ultimately, again, keeping as many people on a payment plan that was reasonable and they could stay on was a business purpose as well.
And would you say that money spent mitigating the accrual of bad debt, as you say, would you say that the money spent by Evergy to accomplish that will have a beneficial effect for ratepayers?
I'm sorry.
I think we lost you there.
Yeah, you froze up on me. I don't know if that's on my end or your end.
So you referenced mitigating bad debt. Oh, I think we're. Mr. Kaisley, are you there?
Okay, I think it looks like his connection is degraded.
Pardon
Mine
the
is.
Judge. Pardon the interruption, Judge. This is Caleb from OPC. If I might suggest, it appears Mr. Casey is having a bandwidth issue. If he turns off his camera, that might help.
Yeah, that would be fine with us.
There we go. Maybe this will work a little better.
Great. Mr. Casey, I'll repeat the question here and let us know if you get cut off again.
Okay.
You referenced mitigating bad debt. One of the purposes here of this program was to mitigate the accrual of bad debt by customers. Would you say that investment by Evergy could lead to a beneficial outcome for ratepayers?
Certainly, I think anytime you reduce bad debt, it's beneficial to everybody. And like I said, when we started the moratorium in March, our accounts receivable balances, excluding pay arrangements, were right around $144 million. As of the end of last week, we were at $141 million of accounts in arrears. Again, excluding payment arrangements. But when you include the payment arrangements, then, our total balance today is, probably around, just right around, looks to be like $15 to $16 million of more accounts receivables on our books than were at the time of the moratorium and when the pandemic first really hit. And our total amount to pay off all balances is about $70 million higher than it was at the start. So it continues to grow. It's not uniform every single week or every single month, but in general, the balance of total accounts receivables and balances on pay arrangements continues to grow.
And thank you. And would you estimate that number would continue to grow if the pandemic were to become significantly more severe?
Yes, I think if we go back into a lockdown again, then I would say we would be in a situation where that would continue to grow probably faster than it is now. It's slowed over the past several months, but I would expect that it would start growing again if we went into a lockdown situation.
Okay, thank you. I want to briefly just go back to page 4 of your sir rebuttal testimony. You stated, this is line 3, your answer there. You stated you're confident in telling the commission that Evergy's been an industry leader in your response to customers' needs during the COVID-19 pandemic. Do you see that?
Yes, I do.
Would you still consider Evergy an industry leader in this area?
I do, yes.
And why?
I think there's multiple reasons. First, from conversations with many of my peers and other utilities, I can tell you that they in general have higher number of people who are eligible for disconnection at this point than we do, and I think that it is a significant benefit to our customers, and I think it's a significant benefit to our company and the community we serve. That from the day this started, right out of the gate, we were one of the first utilities in the United States to announce a moratorium. But then secondly, we immediately went into looking at how could we come out of that moratorium and do it in a way that wasn't significantly disruptive to businesses and to lives in our communities. And I think the first proof point there is that as we sit here today, as I stated earlier, we're about $3 million under the amount of folks that the accounts are down and the amount of dollars that are in arrears and eligible for disconnection as we sit here today, 6 to 7 months after when this started. is less than when we began. And I think that only happens if you take some extraordinary measures and do things that, frankly, we hadn't done before. And I would say a significant amount of utilities around the country still have not taken. Now, does that mean we're the best? No, I wouldn't say that. I'd always say that there are things we can look at to do better. But I do think we did some things and some immediate and ongoing mitigation steps that were significant. So you asked for examples. One of the first people to announce a moratorium, as I mentioned earlier. We immediately, very aggressively, very proactively started communicating with our customers and other stakeholders and groups in the community. We expedited the hiring and training of 2 classes of customer service representatives. We took and went from 20% deployed remotely capability for our call center representatives to now we're almost 98, 99% deployed remotely, so we had no interruption in service there. We targeted and expedited the deployment of around 15 to 16,000 AMI meters with automatic disconnect and reconnect in order to be in a situation where once we came out of the moratorium, whenever that ended up being, because we didn't know at the time, when people were disconnected for non-payment, we could reconnect them the moment that they made a pay arrangement with us rather than having to roll a truck. And so out of all of the disconnections that occurred after the moratorium and through the middle of August, only 659 actually had to have a truck roll to go restore service, and most of those were small commercial customers. We immediately got with McKinsey and with Trove to model the impacts to different customer groups and see if we could do some predictive analytics around who would be most affected and what kind of programs we could put together to work with them. We set up a cross-functional task force internally to look at this, not just from an operational perspective, but from a more holistic and community perspective. I mean, there's just many, many things in addition to doing the programs that contain bill credits for people who would make arrangements with us, whether it was a 1-month payoff, a 4-month payoff, or a 12-month payoff. I would say still most utilities, at least that are within the EEI member companies, as well as many of the co-ops and municipal utilities that we have information on, did not have or do not have those credit programs. And again, as a result of bill credit programs and as a result of all of this, we're still evaluating what else it is that we may need to do, particularly if we go into lockdown again. So no, but I do think we did some very good things and perhaps some industry leading things in some areas.
Sounds like you took some early steps. Are you familiar with the customer programs offered by other Midwestern utilities of Evergy's size, and specifically their levels of investment in those programs?
I don't have any specific knowledge of like for example, yes, on calls that we have with the Edison Electric Institute, we all share what it is that we're doing. Could I recall them or list them for you right now? No, I couldn't.
Would you consider Evergy a leader in the level of investment it has committed to arrearage management and similar programs, in particular the level of shareholder investment?
I would consider for our size and for the situation that we are experiencing, what we are doing is doing the trick, I think.
Would you consider Evergy a leader among your peer group in terms of level of investment, in particular shareholder investment?
Again, I don't know what other utilities have done in terms of shareholder investment. I do think that if we look at our peer utilities in Missouri, and if we look at our peer utilities in Kansas, if there is a difference, there's not a significant magnitude of difference.
Okay,
again,
thank you, Mr. Casey.
I'm not familiar with the particulars of where they are on arrears and what kind of issues their customers are having. And I couldn't speak to any of the things that I just listed previously, measures that we undertook to whether they've done it or not, or where they sit right now relative to where they were pre-COVID.
Thank you. I have no further questions, Judge.
Thank you very much. So we can now take any questions from the commission if we might have any. I'm not going to do a roll call process. I'd like the commissioners to speak up if they would like to ask any questions. I know you're all respectful to each other and you'll defer to seniority, but whoever has a question, please speak up if there's anyone from the commission.
Judge, this is Commissioner Roop. Mr. Casely, the only question I have is, why is Evergy's situation different than Spire and Missouri American Water?
Commissioner, first of all, good morning. Good to see you. It's been a while. Second of all, in what respect? I guess just a little more clarity would be helpful.
Well, I guess what I'm trying to say is, what's the difference in Evergy's settlement than opposed to Spire and Missouri American Water settlement?
I'm not familiar with the details of their settlements, and probably Darren Ives would be better to delve into that, but I do believe they have, that there could be some programs that they agreed to, which are not contemplated in our stipulation and agreement.
All right, I'll defer to ask Mr. Ives, so he can tee that one up whenever he gets a chance. Thank
Absolutely.
you.
Thank you, Commissioner Roop. Did we have any additional questions from the commission at this point for Mr. Casely? Okay. I was just hoping that you could remind everyone, Mr. Casely, when did the moratorium begin for Evergy's customers, and when did that end? I think it has ended, but perhaps I'm wrong.
It has ended, I believe, subject to a couple of days on either side of this. I believe it was either March 12th or 13th that we went into the moratorium, I believe. Hard to remember at this point, and we can certainly get that exact date. And then we ran through, I believe it was July 15th.
Okay, and just to help me remember how this happened, Evergy came to the commission and asked for a moratorium, and that was approved, and Evergy proposed that moratorium would continue through July 15th, and then that period has expired. Is that how that happened? I could be wrong, so you can explain it to me.
No, we did not seek approval, I don't believe. I believe we just announced it, that we were going to do it. And then when we announced it initially, there was an initial date, I think it was around 45 days, and we said we'd reevaluate, and then we kept extending it multiple times as the lockdown continued and people continued to struggle. Ultimately, we announced to customers about 5 to 6 weeks prior to lifting the moratorium on July 15th. And contemporaneously with announcing those, when the moratorium was going to be lifted, we engaged in a very significant proactive communication campaign, and also announced the programs that we were offering to try and help customers deal with accounts and arrears and issues.
Okay, and I have one other issue I wanted to clarify with you. Is Evergy's arrearage management programs, does that include any kind of arrearage match or relief that allows a customer who owes money to actually have some of that arrearage forgiven or something along those lines?
It did. When we announced the moratorium was going to end on July 15th, we announced 2 programs that would allow folks to get some forgiveness of their arrearages for setting up payment plans and for keeping them. We had about 9,000 customers, I think is right around there were the final count of customers that enrolled in that. And then those programs expired at the end of August. And one of the considerations we gave to that was that, the number of people by the end of August that we had, or accounts that were qualified for disconnection was down under pre-COVID levels, both in terms of accounts and in absolute dollars. And so we suspended those programs and no longer offer them. However, should they become necessary or should we see a change in the overall situation economically or the pandemic, we would absolutely consider those again and have agreed to that in the stipulation. And I would like to add just one other thing to that. I know in this particular proceeding, we're on the opposite sides of the issue, but Dr. Mark and OPC were extremely helpful, and so was staff, who we did sign the stipulation with in this, in getting those programs reviewed and discussed and really acted very quickly so that we could offer those programs to customers. And we just really enjoyed the partnership on that, and the fact that we did get 9,000 people, enrolled in those programs with a level of arrearage forgiveness.
Okay, and just to make sure that I understand it, it'll save me a little time. Were those programs subject to a commission proceeding, or was that another thing that Evergy did voluntarily on its own without having to go through the commission process?
We did not. It was voluntary, and we asked for expedited treatment. And I'm not sure if we got an order on that, or we'd have to. You'd have to probably Mr. Ives would be the right one, or our counsel to go back into the details of that. I just know that normally being able to do and launch those types of programs takes a considerable amount of time, and was very just thrilled that we could do that as quickly as we did.
Okay, those were the only questions that I had. Thank you, Mr. Casely.
Thank you, Judge.
I will open it up, and of course, commissioners are free at any time to interrupt if they have something that they want to ask. And then if not hearing any of those immediately, we can go on to any recross that anyone might have if they think that's necessary, if staff has anything that they wanted to add. Okay. And Missouri Industrial Energy Consumers, if you wanted to ask anything, I would give you a chance. Okay, I can see from the video that Ms. Thank you very much, Ms. Plesha. And Midwest Energy Consumers Group, Mr. Woodsmall, if you wanted to ask anything, now would be your chance.
Nothing, Your Honor. Thank you.
Thank you. Sierra Club, did you have any questions at this point? Ms. Henry is indicating no. Renew Missouri, was there anything that you wanted to revisit?
No, thank you, Judge.
Thank you. And Office of the Public Counsel, Mr. Hall, did you have anything?
No, thank you, Judge.
Thank you. National Housing Trust, that leaves you, Mr. Linares. Did you have anything, sir?
No, thank you, Judge.
Okay. And would Evergy like to do any redirect with Mr. Casely today?
Just a little bit, Your Honor. This is Rob Hack. Can you hear me, court reporter?
She's indicating yes.
Very good. Mr. Casely, let's go back to DR 2027 that OPC provided to you, and also would like to, in connection with that, go to your surrebuttal testimony on page 11. Are you there?
I am.
So if you recall Mr. Hall's questions about the $400,000 pledge, that pledge is where you referenced grants to nonprofit agencies at the front line of COVID response, dealing with food insecurity as an example, or housing insecurity as an example, and potentially even energy assistance as an example. Is that correct?
Yep.
And that's on page 11, lines 13 through 19 of your surrebuttal, correct?
That is correct.
And lines 20 through 24 of your surrebuttal deal with an $800,000 pledge for Evergy's Hometown Economic Recovery Program, correct?
That is correct.
And DR 2027 deals with Evergy's Hometown Economic Recovery Program, correct?
That is correct.
So they're really two different programs, two different pledge levels, and your response regarding the potential for energy assistance was really in reference to the $400,000 grant, whereas the $800,000 addressed in the DR 2027 is for something else, correct?
That is correct.
Thank you. In terms of the accounts receivable balances that have been climbing and amounts subject to payment plans that have been climbing during the pandemic, would you attribute the bulk of that increase to Evergy's offer of 12-month payment plans?
Yes, I would. I think that was probably almost exclusively the driver.
In your experience, and this relates to the disconnect moratorium questions that were asked by a number of people, in your experience as the Chief Customer Officer of Evergy, do some customers seem to require some form of collections activity, whether a threat of disconnection or actual disconnection, before they will pay?
Absolutely. It is. We hoped to honestly prove that not to be the case. That was one of the goals that we set out to see if we could devise some programs that, absent the threat of disconnection, we could significantly reduce the number of folks who were eligible for disconnection and take a real crack at the amount that they had in arrears. And we did get 9,000 customers who ultimately, in a very short time period, enrolled in those plans. But what we found out in dealing with customers is the biggest thing that they were most interested in when we were talking to them about the plans, the vast majority were more interested in the time period with which to pay. In other words, the 12-month payment plan was extremely popular. And then the second one is that there is a significant number of customers who just simply will not prioritize paying this bill unless there is a threat of disconnection. And we have not found something that adequately addresses, or adequately moves folks as much as that obviously does.
And in your conversation with Mr. Linares on behalf of NHT, there was a reference that you made to customer programs mitigating bad debt levels as being a reasonable objective. You recall that discussion?
I do.
But that is only one side of the equation. Would you agree?
I would agree.
And do you not also need to assess the level of cost associated with those programs in comparison to the level of bad debt reduction?
Absolutely.
And based on your experience, at least in our service territory here in Missouri, where customers, at least some customers, require collections activity to pay, if an arrears management program, significant element of it is the absence of collection activity, do you have concerns about customers actually paying?
I do. And one of the things that we found as part of the moratorium, interestingly enough, is that there's this, and we're going to do some work at the end of this year and into next year to dive deeper into this. But there's a significant number of customers when you announce that there's no a moratorium on disconnections that have the ability to pay that just stop paying.
And one last question. After the disconnect moratorium ended for Evergy in Missouri in mid-July, can you characterize or compare the level of disconnection activity for that part of the summer and fall this year for Evergy during the pandemic to more normal years?
Yes, it was very similar in terms of the number of disconnects and the hours worked. Again, that was a goal beginning at the when we started the moratorium. A goal was not to come out of it and have tens of thousands or hundreds of thousands of people more in a spot where they'd be eligible for disconnection, both from a life, quality of life perspective, the stress and the financial issues associated with that, but also just a cost and an exposure issue for the company. It was a goal that when we came out of this, we could maintain our customer service levels in the call centers. It was a goal that we rapidly get underneath the level of accounts eligible for disconnection and the amounts in arrears, which again, at this point, we are holding underneath where we were pre-COVID. We go into a lockdown again, I would expect that to be different.
I think that is all of the redirect that I have, Judge. Thank you, Mr. Casely.
Thank you.
Okay. Assuming that there are no late coming questions from the commission, that will conclude Mr. Casely's testimony today. So it's 11:35. One thing we need to discuss is whether we're going to move up a witness for Sierra Club. Ms. Henry has indicated that attorney availability might require that. So Ms. Henry, I don't know if everyone was on the line when you mentioned that, so you just want to remind us what's going on there?
I have a conflict tomorrow. Thank you, Your Honor. I have a conflict tomorrow and cannot participate in the hearing tomorrow. So I was wondering if we could move Ms. Roberto up to make sure that she can be presented today.
Okay, so, and she needs to appear today. So I would suggest that what we would try to do is slot her up after Evergy's witnesses, assuming that we can wrap them all up and then do that. So we'll keep an eye on the clock to do that. Does anyone in particular staff have a problem with moving Ms. Roberto up after Evergy?
Staff has no problems with that.
Okay. So I think that's what we'll do. We'll plan on swapping that person up for the day. And then I wanted to break at 11:45 for agenda. That gives us a little bit less than 10 minutes here if we wanted to get something else accomplished. The next thing on our task list would be to let the commission ask questions of attorneys based on comments that were made in opening. I don't know if we can handle that productively in less than 10 minutes. So unless someone has a burning question that they want to ask right now before agenda, and that someone would be a commissioner, I would suggest that we would go into recess and go off the record until we come back after agenda. And I would propose that we would do that at 1:15 p.m. Is that going to give everyone enough time to attend agenda and eat some lunch and come back here ready to question counsel? Does anybody have a problem with that schedule? Okay, well, it looks like that's what we're going to do. So we are off the record at this time. We'll be back at 1:15 after agenda. Thank you all.
Judge, before you leave, do we need to do anything logistically to connect back onto the hearing after lunch, or can we leave this on, or what's your recommendation?
So I think this is a test of how superstitious a person is, but I am just going to shut off my video and mute my line because I don't trust that everything will resume. But I've done a little research, and according to Google, we should be able to disconnect and come right back on. So, I just wasn't going to do it because I had kind of middle of the night nightmare last night that I would disconnect and then everything would go haywire. But I think everyone should be able to disconnect and come right back on.
I think I'll follow your lead. Thank you.
Okay, see you all at 1:15. Everything okay on your end, Ms. Bench?
Perfect.
Okay, great.
I'm actually in Colorado today.
How nice.
Yeah.
I bet it's a little chilly.
Yep. I've been here. I've been here. This is like the last part of 4 weeks.
Wow.
Yeah, my sister lives out here, so I'm visiting her, and so my husband came out Friday night, and we're gonna go home Monday.
Are you driving?
Yeah, we're
Yeah.
driving.
Yeah.
Yeah, we've had snow twice out here.
Yeah, I believe it.
And then we've had, 75, 80-degree weather too. So.
Yeah. Yeah. Well, it sounds like a nice trip.
Yeah. And with all this WebEx and Zoom, I've been able to do some work while I've been gone.
Yeah, there's a little silver lining here and there.
One good thing about COVID.
One good thing. Well, I think they've got really good broadband out there because you sound nice and clear today.
Oh, good. Yeah, I've had pretty good luck. I got a brand new iPad just for the occasion of doing this out here.
I'm going to bring our web stream back in here pretty soon once I see a few more people.
Okay.
Looks like Justin's already with us. That's weird. Okay. All right, so we should be streaming right now. And people are starting to show up on video and otherwise. I hope that was just the right amount of time for everybody. Waiting to see if we get some commissioners on here with us. We have a couple minutes to go. And Justin, I assume our stream is live?
Yes, ma'am, it is.
Okay. All right.
Still
So it's
showing intermission until you say otherwise.
okay. Right. We're not there yet. I just wanted to know if we had you where you needed to be. It sounds like it.
Yep, I'm good.
Okay. So it's 1:14. I see we have Commissioner Roop with us. And we'll be getting back on the record here in about a minute. Looks like I accidentally moved you into the lobby, Justin. But we have you live with us and we also have the stream, so we're okay now. Okay, good.
Yeah, we're good now. That was just
Okay.
a few minutes ago.
Okay, great. I don't see the email automatically. I have to look over there to see that I have messages, so.
No worries.
Okay. All right, it is now 1:15 p.m. and that's when I said we would get started. So we will get this proceeding back on the record today. So where we left off was we were getting ready to have questions from the bench for all the parties, attorneys who made opening statements as we got started this morning. So we're going to kind of backtrack and do that. So we'll go in the order of the parties' comments to the commission, and it sounds like we might have some more people joining us. If we have a commissioner on the call, would you speak up so I can be aware of your presence? Okay, I see Commissioner Roop, so that line must not be a new commissioner joining us. Okay, and then it looks like the conference line from Kansas City was making a little noise, but you guys fixed that, so thank you. All right. Unless anyone has anything to start with, we can get started with any questions that anyone may have, or I'm sorry, that commissioners may have for Evergy's counsel. Mr. Fisher made the comments to the commission. Commissioner Roop, did you want to ask Evergy any questions?
I just had that question for Mr. Ives, but whenever it's his turn, he can address that.
Okay. And I am not at this point seeing other commissioners with us on the call at this point. So I think that one thing I will address right now, and this would be addressed to all the attorneys just so that you're aware of this. The commission's going to ask for briefing in this case to include the issue of the commission's authority to attach conditions to an accounting authority order, and specifically in relation to the conditions that the Office of Public Counsel has recommended if the commission were to grant an accounting authority order in this case, and also the recommendations that National Housing Trust has made in regard to conditions. And because I see that Mr. Linares has just joined us, I'm going to go ahead and repeat that. So we are getting started with any questions that the commission might have for counsel after your opening statements today. And I think a question that the commission will have in general and that the parties will be directed to brief would be an issue of the commission's authority to attach conditions to accounting authority orders. Specifically in relation to the types of conditions, as I said, the Office of Public Counsel has indicated should be attached to an AAO in this case, and the kinds of conditions that National Housing Trust is recommending. So this is just your first, I guess, advice that should be included in your briefs. So that is a larger issue that council could address now if they wanted to as well, if you want to talk about that right now. So since the commission didn't have any, or commissioners did not have any questions at this point for Evergy, did council for Evergy want to address that authority issue?
Judge, I think we could just brief that issue, and we'd probably prefer to do that.
Okay. All right, so we aren't hearing anything directed to Evergy based on opening statements. What about staff? Any commissioners want to direct any questions to staff? And I think what probably will be more efficient in this situation is to simply open the floor to any commissioners who want to hear any argument from or statements from the party's counsel at this point about any of the issues that were addressed in opening statements, rather than going through a roll call process. So all of these fine lawyers are here today. So if anybody wanted to ask them to answer any questions, they've all made clear that they're available to answer the commission's questions. So I'm sure if the commission decides later on that they want these folks to answer some questions, that these lawyers will be happy to do that at that time as well. So I am not hearing an email or seeing any indications that the commission needs to hear any statements from additional arguments from attorneys at this point. So I think we can consider that we've satisfied that part of the process. And should the commission decide they want you guys to answer some questions later on, I'm sure that they will bring them up at that point. And you're now on notice that your briefs in this case need to address that authority issue in relation to conditions. So that means that we're back in the position of being ready to take testimony again. So we would be picking up again with Evergy's witnesses. I know that Sierra Club was hoping to get Cheryl Roberto, her presented today, and I see that Ms. Roberto's with us on the call. I think probably it would make sense to try to get Evergy taken care of first, and we should have time to do that. So unless for some reason people have better foresight than I do, I think we'll go ahead and do that. So let's go ahead and pick up again with Evergy's witnesses. And I believe that would be Mr. Clote.
Yes, this is Rob Hack, and Evergy would call Mr. Clote to the stand.
Okay. And is Mr. Clote's going to be on the video with you that is labeled as Darren Ives right now on WebEx? Is that right?
That is correct. That's
okay.
Mr. Clote that you see right now.
So you see that, Ms. Bench? Looks like you're aware of where Mr. Clote is. Great. Okay. So, Mr. Clote, would you raise your right hand, sir? Do you solemnly swear or affirm that the testimony you are about to give in this hearing will be the truth?
Yes.
Thank you very much, sir. Okay, you can proceed.
Thank you, Your Honor. State your name for the record, please.
That's Ronald A. Clote.
And by whom are you employed, Mr. Clote, and in what capacity?
I'm employed by Evergy Metro, and I'm the Director of Regulatory Affairs.
And Mr. Clote, did you cause to be prepared and filed in this docket certain direct testimony marked as Exhibit 4 and surrebuttal testimony marked as Exhibit 5?
Yes, I did.
And do you have any changes at this time to those pieces of testimony?
No, I don't.
If I were to ask you the questions posed in those testimonies today, would your answers be substantially the same?
Yes, they would.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
And can you identify Exhibit 1?
Yes, that's the stipulation and agreement that was entered into with certain parties in this case.
And you are aware of the correction made, the typographical error correction made on page 8 that Mr. Casely discussed?
Yes, that's correct. Changing the year from 2021 to 2020. Yes.
And does the non-unanimous stipulation and agreement, Exhibit 1, as corrected, represent the outcome that Evergy advocates in this proceeding?
Yes, we still stand behind the testimony we filed in a direct rebuttal, but do believe that the stipulation agreement arrives at a reasonable outcome between parties.
And finally, Judge, Evergy would offer into the evidentiary record Exhibits 4 and 5 and tender Mr. Clote for cross-examination.
Okay, Exhibits 4 and 5 appear to be Mr. Clote's direct testimony and surrebuttal testimony. Does anyone have any objection to those being admitted into the record? Hearing no objections, Exhibits 4 and 5 will be admitted to the record. And we can proceed with cross-examination of Mr. Clote. Does staff have any cross-examination?
No questions, Your Honor.
And Missouri Industrial Energy Consumers. Unfortunately, Ms. Plesha, it looks like you're muted.
I'm sorry. No questions. Thank you.
Thank you very much. Midwest Energy Consumers Group, Mr. Woodsmall.
Yes, thank you, Your Honor. Just briefly. Good afternoon, Mr. Clote.
Good afternoon, Mr. Woodsmall.
Do you have a copy of the stipulation in front of you?
Yes, I do.
I want to take you through a couple of the provisions that are in there and make sure we have an accurate understanding and agreement of what those provisions provide. Are you familiar with the items that are eligible for deferral under provision 2 of the stipulation?
Yes, I am.
And one of those is paragraph 2C, which talks about the deferral of program costs. Is that correct?
Yes, it does.
Now, would some of the program costs that are eligible to be deferred under that provision, would that include the 1 and 4 month programs discussed in paragraph 16?
Yes, it would. It would include both the 1 and the 4 month, and could include additional costs that might be related to communication of those programs to the customers.
Okay. In the provision, the stipulation also provides for the deferral of certain savings. Is that correct?
Yes, it does.
And as provided under the stipulation, those savings would simply be netted against the deferral of any cost. Is that correct?
Yes, that is the intention, that they'll be netted against the regulatory asset.
And one of the savings that would be deferred would be training cost.
Yes, that's one of the savings identified.
And one of the other savings that could be deferred would be any savings associated with compensation, employee reductions, benefits. Is that correct?
Yeah, well, that is a savings that is listed, and it's theoretically possible. Currently, Evergy has no plans associated with reducing those costs. We have gone through some voluntary exit programs that are associated with the merger, but at the present time, Evergy has no plans to have reductions in those areas.
But if it happens in the future, those could be deferred under this provision.
Yes.
Did you hear that question?
Oh, I'm sorry. Yes, I said yes.
Okay, I'm sorry. Are you familiar with the acronym CARES Act?
Yes, I am. The coronavirus assistance
and
relief.
Would you agree that income tax benefit deferred under this?
You kind of cut out there, but I believe you. But I believe you asked me if it was the income tax benefits associated with that.
Could Mr. Woodsmall, would you just repeat the question, please?
Yeah, I'm having some, I think some bandwidth problems, so I just turned off my video.
Thank you.
Would you agree that income tax benefits under the CARES Act could be deferred under this stipulation?
Yes, those would be costs that would be netted against the reg asset.
And similarly, to the extent that Evergy receives any state or federal assistance, that would be deferred under this provision as well?
Yes, they would.
I'm sorry, I didn't hear that answer.
I said yes, they would.
Your Honor, can you hear me, Your Honor?
You're on mute, Your Honor.
Thank you. You might want to disconnect Mr. Woodsmall and just call in using the dial in instructions if you're having a difficulty with the computer connection. Because we can hear you.
Let me try. Okay, let me try patching in one more time. I'll be right back.
Sound like everybody else, I think.
Judge?
Yes.
You might want to make sure everybody else is muted. Maybe that could be a problem.
So we might be getting a lot more ambient noise from some other lines. So if you can mute yourself, please do so. The room that has the most ambient noise is actually the room where our witness is sitting right now. So
Can you hear me now, Your Honor?
I can hear you, Mr. Woodsmall.
Great, thank you. Mr. Cloak, can you hear me?
Yes, I can hear you just fine.
Okay, thank you. Going back one question to make sure I got the answer. If Evergy receives any state or federal assistance, those benefits would be deferred under this provision. Is that correct?
Yes, they would.
Now I wanted to ask you about the duration of the AAO. Are you familiar with that provision in the stipulation?
Yes, I am.
Okay. And the provision as it's written, it provides for two different possible expiration dates, one being for the bad debt expense and one being for everything else. Is that correct?
Yes, that's correct. The bad debt expense will go through September 30th of 2021, with the last 6 months being included as part of a test on comparing the bad debt expense that are in rates versus the actual write-offs that occur during that time frame, and all other costs of the AAO will end as of March 30th of 2021, and the parties have the ability to have discussions if there's a need to extend that from that point in time.
Okay. And when you talked about the bad debt expense provision, it compares actual bad debt that's experienced on a quarterly basis to the amount of bad debt that's included in rates. Is that correct?
Yes, it does. It uses a measure of 10%. If write-offs exceed the amounts that were included in the last case by 10%, then that triggers the ability to defer. If the amount of write-offs that occur during that 6-month period are less than the 10% threshold, then that will offset previous deferrals.
Okay, and Exhibit 1 of the stipulation provides the amount that's built into Evergy's rates currently. Do you see, is that correct?
Yes, it does.
And are those numbers accurate to the best of your knowledge?
Yes, they are.
Okay, and just so I'm clear, when we go to make the comparison of actual bad debt that's experienced to the amount in rates, are we comparing to the third column, Missouri Metro or Missouri West monthly percent, or to the final column, bad debt and rates?
When you say column, Exhibit 1.
Do you have Exhibit 1 in front of you?
Oh, excuse me. I was still in the word section part. Could you ask that question again?
Yeah, Exhibit 1 of the stipulation, do you have that in front of you?
Yes, I do.
Okay, there are 5 columns there. There's a column listed Missouri Metro monthly percent of total, then a 4th column distribution of difference, and 5th column bad debt and rates. It looks like the 5th column is just adding columns 3 and 4. Is that correct?
Yes, that the amount that's included in bad debts, that's the last column on that page, correct?
Okay, so that will be the column to which we make a comparison on a quarterly basis. Is that correct?
Yes, that's correct.
Okay. I wanted to ask you, some questions about the reporting provision. Are you familiar with that?
Yes, I am.
Can you tell me your understanding of that reporting provision?
Yeah, the reporting provision includes items that provide parties customer payment behavior and provide balances of accounts receivables that are outstanding at a given point in time.
Okay. And do you believe that the reporting provision is reasonable?
Yes, I do. Much of the data that we'll be supplying in that report is data that we have been already supplying to parties.
I wanted to ask some questions about provision 13, accounting practices and procedures. Are you familiar with that provision?
Yes, I am.
And can you tell me what your understanding is for the need for that provision?
I believe for this provision, it's to provide how the company is going about tracking and accounting for the items that have been included in the stipulation, and this discussion will be provided to all the parties so that they can see exactly how the company is going about tracking these items.
And is it your understanding that that provision or that information has previously been provided in the context of a data request response?
Yes, I believe it has.
And do you think the provision is reasonable?
Yes, I do.
Your Honor, I have no further questions. Thank you, Mr. Clote.
Thank you.
Thank you. Does Sierra Club have any questions for Mr. Clote?
No questions, Your Honor.
And any questions from Renew Missouri?
Thank you, Judge.
And Office of the Public Counsel?
Thank you, Judge. Good afternoon, Mr. Clote.
Good afternoon.
Mr. Clote, can you speak to Evergy's capital investment plans?
In what regard?
Evergy, any changes Evergy has had to its capital investment plans given the emergence of COVID-19?
The company does have capital investment plans. That's not part of the function that I perform in the company, but we do have modeling of our capital financials.
Mr. Clote, I'd like to refer you to what has been marked as Exhibit 205. Is there a method of getting that in front of you at this time?
Yeah, I've got it.
I have it.
Mr. Clote, can you do you agree with me that this is a data request that was sent to Evergy Missouri Metro and Evergy Missouri West from the Office of Public Counsel?
Yes, it is.
And that the answer is verified with the signature from Mr. Brad Lutz on the third page of the document?
Yes, I see that.
Am I reading the question? There's multiple questions phrased in the full total question, but we are asked, do you agree that the question generally is, has Evergy Missouri Metro or Evergy Missouri West conducted any analysis to determine whether or not their planned capital investments need to be altered because of COVID-19? And what were any conclusions of such analysis?
Yes, that's what it says.
Do you have any reason to believe that the response from Evergy to this question is in any way inaccurate or dated? Out of date?
No, I don't. We continue to evaluate our capital investment plan, but I have no reason to believe this question is out of date.
So, Evergy's answer to this question was that no such analysis had been conducted. Am I correct?
I don't think it says no such analysis being conducted. I think it says, while not specifically conducted to determine whether planned capital investments need to be altered because the overall analysis is key consideration. So there is analysis that happens.
Thank you for that clarification. So there's a continuing analysis, and the company believes there is enough short-term liquidity to avoid altering any planned capital improvement plans. Is that correct? Or not capital investment plans?
Yes, that's what the data request stated.
Thank you. Your Honor, at this time, I move for the admission of Exhibit 205 into evidence.
So I don't believe I've received that exhibit. I was looking on what you provided this morning.
My apologies, Judge. I believe that was sent out.
So I can see 208, 209, and 210.
For good measure, Judge, I'm sending it along with exhibits. So you said you have 206 through 208? Or, I'm sorry, Judge, could you repeat what you said that you have?
Yes. I'm finding your message again. This morning at 9:25, I received a message from you with 3 exhibits, Exhibit 208, 209, and 210. To my knowledge, those are the only exhibits I've received other than the document that you asked a witness to look at earlier today and didn't want to offer as an exhibit.
I apologize for this repeated inconvenience. I know I've been sending them. Cheers.
So
Okay, now you should have it.
thanks for everyone's patience. So it's ironic, but it looks like maybe the OPC and PSC Outlook programs are not playing well together, but I'm not receiving anything. So there are lots of different, okay.
Do you want me to send it from my email system? Because they might be more friendly.
Yeah, we might as well try.
Right. Can I get confirmation from any other party? I just sent an email to all the parties of record and the judge that has that exhibit. Are my emails not reaching anybody?
Caleb, what did you send it just recently?
Yeah, 1 minute ago.
So I don't have anything yet.
Here we go. I've received a reply to you. that you sent from my test message earlier today. So now I have it. So Ms. Henry, I don't think you need to do anything. So now I have an Exhibit 205, which was the DR 2017. And I trust all the rest of the parties have identified this document and are aware and familiar with it. Mr. Hall has offered it into evidence. Were there any, unless I'm assuming something, I think we got that far, Mr. Hall, right?
Right. I'll renew
Okay.
my list at this time.
Okay. So this has been offered into evidence as Office of Public Counsel Exhibit 205. Are there any objections? Okay, hearing no objections, Exhibit 205 will be admitted. And it is not a confidential exhibit. Okay, thank you very much, Mr. Hall. You can proceed.
Thank you. Mr. Clote, do you recall a case filed by Office of Public Counsel and Midwest Energy Consumers Group asking for an accounting authority order regarding the Evergy's closure of the Sibley electric plant?
Yes, I do.
Did you participate in that case?
Yes, I did.
You testified last year, correct, on this? In that case.
Yeah, yes, I believe it was last year. I'm sorry. It just took me a while to get there.
Oh, it has been a year, I understand. Mr. Clote, do you recall opposing Public Counsel and MECG's requested deferral accounting?
Yes. Yes, we did.
Do you recall opposing it based on your interpretation of General Instruction 7 of the Uniform System of Accounts?
If you're something specific you're referring to, I know that was an issue that was brought up in the case.
And you relied on General Instruction 7 of the Uniform System of Accounts as part of the basis for your testimony, correct?
No, I don't believe the company relied on that. It was a data point that has been used, I think, in past commission orders associated with AAO, but as we stated in this case, in any AAOs, it's not case dispositive. Not all AA orders rely on General Instruction 7.
Mr. Clote, I would like to turn your attention to what Public Counsel has pre-marked as Exhibit 210. Is there a way to get that in front of you?
Yes, I have it.
Do you recognize this document?
Yes, it's my rebuttal testimony in the Sibley case.
The same Sibley case, the same aforementioned Sibley case that you referred to, correct?
Yes.
Could you please turn to page 20 of your testimony in the Sibley case?
I'm there.
You have to forgive me. I lost myself while looking through the from lines 8 going on to lines 1 and 2 of page 22. Sorry, let me rephrase that. From line 8, page 20, into line 2, page 21. There's a Q&A where you start a section responding to OPC and MECG's requested deferral accounting, correct?
Can I read it?
Yes, of course.
Okay, I've read it.
On line 20 of page 20, you're referring to General Instruction 7 of the Uniform System of Accounts, correct?
Yes, I am.
And you're referring to this instruction in opposition to OPC and MECG's requested deferral accounting, correct?
Yes, it was a data point that was included in the case, and it's a data point that's been used in previous AAO proceedings, and that's what it's referring to.
Thank you. I have no further questions.
Okay, do we have any cross-examination from National Housing Trust?
No, thank you, Judge. No questions here.
Okay, thank you. All right, so do we have any questions for Mr. Clote from the commission? The floor is now open. We may have some questions from the bench here. Okay, Mr. Clote.
Hey, Judge, this is Commissioner
Yes.
Rubin.
Thank you,
So-
Commissioner.
Is I understand that Darren Ives is not who Darren Ives is showing on his camera. Is he going to be available today, or should I go ahead and ask the questions of Mr. Clote, or just curious of how that's going to work?
So Darren Ives is scheduled to be Evergy's next witness. And I believe he's going to be in that same conference room with on the screen with his name.
Excellent, thank you.
So you will get your chance.
Woohoo!
Yay, okay. So I was going to ask about what incentives Evergy has to maximize, as this was presented to me, the amount of arrearages that are converted to revenue instead of bad debt. And as I understand that, that means what incentives does Evergy have to get customers to pay past due bills as opposed to treating it as bad debt?
Right, and I think from the testimony that was provided by Chuck Casely previously, there are programs that we put in place to help manage the arrearages that the company is experiencing. And by doing those programs, I think we provided testimony, I believe it was in Mr. Ives, that showed that that the arrearages that began once the pandemic started increased, but once the programs that we put in place, especially the 1 month and 4 month payment plan, and the 12-month payment plan, the arrearages start to decrease, and in actuality, they've been now are below the level than when the pandemic started. Now we do have amounts that are outstanding that are on a payment plan, but they are on a payment plan, and that's how we've been managing that.
So, Mr. Clote, are you familiar with some of the customer-specific recommendations that were made by OPC's witness, Dr. Mark?
I've read the testimony, but customer-specific programs are probably not under my area of expertise.
Okay. Who would you say would be able to address those? Would that have been Mr. Casely or Mr. Ives?
Yeah, I believe definitely Mr. Casely, and you can ask Mr. Ives.
Are you able to address the costs that Evergy has incurred in relation to the 1 month and 4 month payment plans that were offered to customers?
Yes.
Okay, so is there more that you could tell us about those costs?
Well, we've actually been tracking those costs. Once we initiated those programs, the costs associated with the 1-month and 4-month programs, the customer received a credit on their bill. And I believe in the 1-month program, if the customer paid their bill, they received that credit. In addition, on the 4-month payment program, I believe they received a discount after the first month, and then if they followed through on the additional 3 months, there will be a credit that will be included on that bill. In addition, associated with those programs, we made a significant customer outreach associated with those programs, and any costs associated with that, we would track in this AAO.
Okay, and I want to make sure I understand, when the companies applied for an AAO, those types of costs were proposed to be included in the accounting authority order. And now in this posture, as we're coming back to this hearing after having reached a non-unanimous agreement, those costs still would be treated, would be eligible to be deferred under the agreement. All of those different costs that you just described, is that right?
Yeah, the costs associated with the 1 month and 4 month, yes.
As well as the customer outreach?
Yes.
Okay, so I apologize for this because I should have directed this to Evergy's counsel earlier in the proceeding. But now that we're getting deeper into testimony, I just want to make sure that I understand the posture of the company at this point, because the application came in asking for lost revenues, and then that was revised to some degree with an alternative proposal to allow some plan to recover what was being called lost fixed costs. And now we're at a hearing, and I think what I'm hearing from the company is we reached a settlement and that's what we're asking for. And that settlement doesn't appear to include either lost revenue or lost fixed costs. So if counsel for Evergy wants to clarify that for me and the commission at this point, that would be helpful, just to make sure I haven't missed. I'd like to make that crystal clear.
So RLJ Jacobs, this is Rob Hack for Evergy. Can you hear me?
I can hear you, sir.
Okay. The answer is they're under the non-unanimous stipulation and agreement. We have agreed not to defer revenue losses due to load degradation resulting from the pandemic. And I would characterize that revenue loss phrase as roughly equivalent to lost fixed cost recovery that we talked about in our surrebuttal testimony. So neither one of those is being or would be deferred if the commission were to approve the non-unanimous stipulation agreement. Is that clear as mud?
Yes, and the only reason it's confusing to me to some degree is because a good chunk of the testimony in the case, including issues that we may be going into today, are going to be addressing the lost revenue and maybe even the so-called lost fixed costs. And I'm just trying to figure out how tedious I need to make it to go into that, or if going into this hearing, Evergy's saying that's off the table.
We have agreed not to defer, and we are no longer requesting deferral of revenue losses due to volume reductions related to COVID and the equivalent lost fixed cost recovery.
Okay, that does clarify things for me, and I apologize. I think there were multiple opportunities for me to glean that from what was stated, but I just wanted to make sure that that was clear.
No problem.
Okay, and then returning now to Mr. Clote, I just had another question for you, sir, and I think Mr. Woodsmall asked you about this in regard to the reporting requirements under the agreement that some of the parties reached. And I was just wanting to clarify the information that would have to be collected to comply with that reporting obligation. Is that all information that Evergy is collecting at this time?
Yes, the majority of the items on there, they're already being provided to staff and OPC in another docket. So yeah, we are collecting that data presently.
Okay. All right. So unless any commissioners would like to ask questions at this point, I would proceed to see if there's any recross from any of the parties, starting with staff.
No recross, Judge.
Thank you. And Missouri Industrial Energy Consumers. Not hearing any. And Midwest Energy Consumers Group, Mr. Woodsmall.
No questions, thank you.
Okay, thank you, sir. Sierra Club.
No questions, Your Honor.
Thank you. Renew Missouri.
Questions. Thank you, Judge.
Mr. Hall, for Office of the Public Counsel, did you have any recross, sir?
And no, thank you.
Thanks. And National Housing Trust.
Thank you, Judge.
Thank you very much. All right. So any redirect for Mr. Clote from Evergy?
Yes, Judge. This is Rob Hack, and I will have just a few questions on recross.
Okay, please go ahead.
So, Mr. Clote, in your discussion with Mr. Woodsmall, you talked about potential areas of savings to be deferred. Do you recall that?
Yes.
And at least to my hearing, there might have been a little bit of lack of clarity there. And I'll just make the statement and see if you agree with it. You did testify that the company has no plans to reduce headcount, compensation, or benefits as a result of COVID, correct?
Yes, that's correct.
And the savings related to headcount reductions, compensation reductions, or benefits reductions that would be deferred need to be related to COVID in order to be recorded, correct?
Yes.
And you further discussed headcount reductions that the company is pursuing for other reasons, not COVID related, like pursuit of merger efficiencies, correct?
Yes, that's correct.
And footnote 1 on page 3 of Exhibit 1, which is the non-unanimous stipulation agreement, acknowledges that and further clarifies that those non-COVID related headcount savings due to headcount reductions or other payroll changes aren't eligible to be recorded to the deferral, correct?
Yes, that's correct.
Okay, thank you. In your discussion with Mr. Hall for OPC related to your rebuttal testimony in the Sibley AAO case, I'd ask you to turn to page 20 of your rebuttal in that case, and that was Exhibit 2, it's on the front page, 209?
210.
210, I'm sorry. And I believe the thrust of his question was, were you citing and relying upon General Instruction 7 of the Uniform System of Accounts? Do you recall that?
Yes, I do.
So I would ask you to read the full sentence that begins on line 18 of that page and ends on line 20.
GMO witness Ives describes why this situation, even if true, does not meet the commission practice and policy of granting AAOs through applying the extraordinary items criteria of USOA General Instruction number 7.
So is it fair to say, Mr. Clote, that you weren't relying on General Instruction 7, you were relying on the commission's practice and policy of granting AAOs through applying the extraordinary item criteria of USOA General Instruction 7?
Yes, that's correct.
And is it fair to say that the company's position, as reflected in Mr. Ives' testimony in this proceeding, in other proceedings, is that the commission is not bound by General Instruction 7 of the USOA in making deferral decisions.
Yes, that's correct, and I believe the record will show that in previous orders as well. So.
Thank you. In your conversation with Judge Jacobs, you were asked, and I may have this butchered, so apologize, Judge and Mr. Cloak, about incentives the company has to, as I interpret it, reduce uncollectible amounts. Uncollectibles result from unpaid bills, correct?
That's correct.
And the greater the level of uncollectibles, the lower the company's earnings, correct?
Yes, that's correct.
And the company has an incentive to maximize earnings, taking reasonable steps, correct?
Yes, they do.
So just the simple earnings impact of higher uncollectibles is an incentive for us to try to take reasonable steps and cost-effective steps to manage uncollectibles expense.
Yes, that'd be true.
You were also talked, and would you agree also, Mr. Cloak, that it's important for the company in trying to optimize its earnings levels and manage its uncollectibles levels to take reasonable and cost-effective steps to do so?
Yes, I think that is an incentive and should be an incentive, yes.
And really the point I'm trying to get to is that reducing uncollectibles by $100,000 as a result of spending $1 million in incentives or arrears forgiveness or things like that, that's not a good trade-off, is it?
No, you definitely you don't want to chase decisions by spending more than the result that you would get from it.
So you missed, excuse me, Judge Jacobs asked you about the costs associated with the 1 and 4 month programs. You recall that?
Yes.
Do you have the actual information about the costs that have been recorded to the deferral for those programs as of, the end of September?
Yes, I do.
Can you get that and tell us what that is? And it would be by operating utility in Missouri.
Yeah, we track it separately between Evergy Missouri Metro and Evergy Missouri West. And
so maybe I'll just clarify. I want, for purposes of this, just the 1 and 4 month incentive costs.
Yeah, so for Evergy Missouri Metro through September, the cost there would be $38,119, and for Evergy Missouri West through September of 20, it's $31,028.
For both the 1 and 4 month plans?
That's correct.
And that does not include communications costs?
It does not.
Okay. Now let's also talk about, and these program costs would be eligible for deferral under the non-unanimous STIP that we put forward before the commission.
Yes, they would.
There are other costs that the company has incurred to help customers that would not be eligible for deferral, correct?
Absolutely.
Can you, so one of those costs is the $1 million in energy assistance contributions. And that applies, to be clear, both to the state of Kansas and Missouri. Also, the company will not seek recovery of the $400,000 in grants that we discussed with Mr. Casely earlier.
That's correct.
And that is split between Kansas and Missouri as well.
That's correct.
And then there's another tranche of $800,000 in company pledges that will also not be eligible for deferral and will be borne by shareholders, correct?
Yep, those have been excluded.
And there is one other program that was implemented this summer that it's been categorized as highly confidential. It's a CSR discretion program. You recall that?
Yes, that's correct.
Do you have the figures and the incentives or the awards, the grants that the company made under that CSR discretion program are treated as charitable contributions by the company below the line, won't be requested for recovery, correct?
That's correct.
Will not be deferred?
That's correct, no deferral.
Do you have the dollar figures for those?
I do not have them sitting in front of me. I can get to them.
Okay.
Fairly quickly.
Okay. Sorry, I thought they were on that same sheet.
I know that they are in a range of 100 and in the mid 100,000 range.
For the total company? Okay. And I used the acronym CSR a minute ago. Can you, does that mean customer service representative?
Yes, it does.
Thank you. Now, the non-unanimous STIP also provides that the company will evaluate in the future, after the first of the year, the advisability of offering additional customer assistance programs in consultation with staff and OPC and NHT. Is that correct?
Yes, that is correct.
And if such programs were implemented, would those program costs be eligible for deferral?
Yes, I believe they would.
And the company has also agreed as part of the non-unanimous stipulation agreement to evaluate after the end of this calendar year the advisability of continuing to offer 12-month payment plans that it's currently offering to customers in connection with pandemic?
Oh, yes, we have.
And if it did so, that's enough. No more. Thank you. Judge, those are all the questions I have.
Thank you very much, Mr. Hack. Unless we have some late coming questions from the commission, I believe that we are done with Mr. Ives' testimony today.
Mr. Clote's testimony.
Oh, I'm sorry. It's not fair because it says Ives on the screen. So I meant Clote. All right. That means that we are ready for Mr. Ives, in fact.
And we will have a changing of the guard so that we can get everybody in their proper seat.
Okay. I would propose that we try to get Mr. Ives' testimony taken care of, and then we would plan on a break after that if that works for everyone.
Thank you.
Judge, it's Carl Zobrist. Can you hear me?
I can.
Great. Good afternoon. Mr. Ives, are you ready?
I'm ready. All right.
Okay,
Judge, you
Mr.
would swear in the witness?
Yes, Mr. Ives, raise your right hand, please, sir. Do you solemnly swear or affirm that the testimony you're about to give in this hearing will be the truth?
I do.
Thank you very much. You may proceed.
Please state your name.
My name is Darren Ives, I-V-E-S.
By whom are you employed?
I'm employed by Evergy Metro as the Vice President of Regulatory Affairs for Evergy.
And Mr. Ives, have you caused to be prepared direct and surrebuttal testimony in this case, both public and confidential versions?
Yes, I have.
And has your direct testimony been pre-marked as Exhibits 6 confidential, Exhibit 7 public?
Yes.
And has your surrebuttal testimony been marked as Exhibit 8 for the confidential version and Exhibit 9 for the public version?
Yes.
Okay. And if you were to be asked those questions today, would your answers be as set forth in Exhibits 6, 7, 8, and 9?
Yes, they would.
Do you have any corrections to that testimony?
None that I'm aware of.
Okay. Now, Mr. Ives, as Mr. Hack asked the previous questions, are you familiar with the stipulation and agreement, the non-unanimous stipulation or agreement that has been marked as Exhibit 1?
Yes, I am.
Okay. And are you also familiar with the typographical error on paragraph 8 of page 16 that has corrected the date from December 31, 2021 to December 31, 2020?
Yes, I'm aware.
And you agree with that correction? Okay. And what is your position as far as your stated testimony versus the non-unanimous stipulation and agreement?
Well, in the non-unanimous stipulation agreement, we have signed on and agree that it adequately addresses the issues in the case, although I would continue to stand by the testimony that we put in direct and serve rebuttal to the extent that it is no longer addressed by the non-unanimous stip.
And today, you on behalf of Evergy are recommending the approval of the non-unanimous stipulation and agreement and the terms that are contained therein?
Yes, I am.
Okay. Thank you, Your Honor. At this time, I would offer Exhibits 6, 7, 8, and 9 and 10 to the witness for cross-examination.
Thank you. So I would note that 6 is the confidential direct testimony of Mr. Ives, 7 is public direct, 8 is confidential sir rebuttal testimony of Mr. Ives, and 9 is public sir rebuttal testimony. Those exhibits have been provided to the parties. Are there any objections to those exhibits being admitted to the record?
Yes, Judge. Objection limited to page 11 of Darren Ives' rebuttal testimony, lines 13 through 20. He is relying upon out-of-court statements and opinions of Evergy's comptroller, PricewaterhouseCoopers, and Deloitte. He's offering he's relying on these statements for the truth of the matter asserted. This is textbook hearsay.
So can you help me? Is that the confidential or public testimony, sir rebuttal?
I don't believe his rebuttal.
Judge, if I may, those are not offered as confidential passages in Mr. Ives' testimony.
Okay, so this would be an objection then to 9. Is that right, Mr. Hall?
Correct.
And then you went very quickly there with the passage. I'm sorry, could you repeat the passage that you're concerned about?
Sure.
Just where it can be found.
Page 11 of Darren Ives' rebuttal testimony, lines 13 through 20.
And does anyone have a response to Mr. Hall's objection here?
Yes, Your Honor. This is not classic hearsay. This is simply Mr. Ives is an expert witness, a certified public accountant, stating that his opinion is supported by that of other experts in the field. It is not hearsay. It is simply a reaffirmation of his opinion, which is tendered herein. And I believe the commission itself is not bound by the technical rules of evidence, and that the objection should be overruled.
Your Honor, if I may respond, Darren Ives' testimony literally says the opinions of all these individuals would be considered reliable by experts in the use of the USOA. He is asking the commission to rely upon his affirmation that these people agree with him. This is hearsay.
Okay, so I think that sounds like there was a response there.
I was simply going to say that it is not hearsay. He is simply quoting other authorities, and it is not hearsay. And I would add further, the opinions here are reaffirmed by General Instruction 7, which itself does not link or speak to either regulatory assets or regulatory liabilities or deferral mechanisms.
Okay, So I'm going to, instead of derailing everything right now, I will take a closer look at the passage that is of concern for Mr. Hall, take it under advisement, and I will hopefully let you know tomorrow. But eventually, definitely let you know whether I'm going to sustain that hearsay objection. So what we'll do is, I believe there were 4 exhibits offered, 6, 7, and 8. Is that right? No, and 9, no objection to 6, 7, and 8. So those will be admitted to the record. And then I'll take 9, considering Mr. Hall's objection under advisement. Does that work for everyone at this point?
Judge, just for clarity, exhibits 8 and 9 are the same exhibits, with one version being public and one being confidential.
Right, and I think the clarification was that there was no objection to any of the confidential information, and these are all labeled as separate exhibits. So that leaves 9 as the one that has an objection.
Correct. I'm only speaking now out of concern that both 8 and 9 have the language I'm objecting to. It is merely a matter that the confidential version has certain text that...
In addition.
Correct.
Great, thank you. So 8 and 9 have to be held out until I take a close look at the language and let you all know. So that means that 6 and 7 can be admitted. So 6 and 7 will be admitted. Mr. Zobrist?
Judge, I was just going to say I would offer exhibits 8 and 9 with the exception of the passage on page 11, lines 13 and 20, and believe it would be appropriate to admit them because they have not been objected to by Mr. Hall.
So at this point, the proposal would be that 8 and 9 would be admitted, except for this very small passage.
That's correct.
Contingent on whatever I decide after I have a chance to look at this language, which I'm now very curious about. So that seems fine with me because then we can proceed with the unobjectionable portions being included in the record. I don't know that it makes that much of a difference at this point. I don't intend to let this linger very long. Okay.
Judge, I apologize. I just had a sidebar with Mr. Hack, and if you ruled upon my request, I missed it.
Okay, so I was basically trying to restate it to make sure I understood what it was. So I don't think there's any reason why 8 and 9 absolutely have to be dealt with at this very moment. So I'm going to take the time it takes for me to go back and look at the language that was the issue. And then 8 and 9 will come in depending on that decision. Does that work for everyone?
I think that's fine. We, of course, have no objection to Mr. Ives being questioned on any portion of Exhibits 8 and 9, subject to the objection to page 11, lines 13 through 20, made by Mr. Hall.
Okay. So as it stands, 6 and 7 are in and 8 and 9 are not, and we'll just see if that causes a problem for us, and hopefully I will have time to go back and look at the language soon. So 6 and 7 had been admitted to the record. Okay. And Mr. Hall, you'd made an objection to admission of those documents. I don't know if anyone else had objections to make. I think they would have spoken up if they did. So we've clarified that. And I think where we are is cross-examination. So we'll see if this issue comes up again. I think staff would be up for cross-examination for Mr. Ives.
We have no questions, Judge.
Thank you very much. Missouri Industrial Energy Consumers?
No questions. Thank you.
Midwest Energy Consumers Group?
Very, very briefly. Good afternoon, sir.
Good afternoon.
I took Mr. Clote through a number of the provisions in the stipulation. Do you have the stipulation in front of you?
Yes, I do.
I was going to ask you a very brief question about provision number 6, which is entitled Lost Revenues. Do you see that?
Yes, I see it.
And as I understand it, this provision precludes Evergy from deferring any lost revenues associated with reduced customer usage. Is that correct?
Yes, that's right. As part of the non-unanimous agreement.
Okay, and just to tie everything together with some questions from the ALJ from previously, this would not only preclude the lost revenue request from your direct testimony, but also the fixed recovery request that was in your SIR rebuttal. Is that correct?
That's correct. The fixed recovery that was in SIR rebuttal would be a subset of the lost revenues that were in my direct.
Okay, and do you believe this provision is reasonable?
Based upon all the other items that are included in this non-unanimous stipulation, that would be my position, yes.
I have no further questions. Thank you.
Okay, thank you very much, Mr. Woodsmall. Does Sierra Club have cross-examination?
No questions, Your Honor.
Thank you. And Renew Missouri
Thank you, Judge.
and Office of the Public Counsel.
Yes, thank you. Mr. Ives, good afternoon.
Good afternoon.
Do you have copies of your testimony, both rebuttal and SIR rebuttal, in front of you?
My direct and SIR rebuttal, yes.
Oh, direct and SIR rebuttal. Thank you. Did you do you rely on several out-of-state commission orders when you were developing your testimony?
I reviewed a number of out-of-state commission orders. There's also reference to in-state commission orders addressing deferral treatments. So yes.
Cool. Mr. Ives, could you turn to page 11 of your direct testimony?
I'm there.
I believe. Are you referring to Arkansas Public Service Commission order on this page?
At the bottom of page 11.
You are citing to an Arkansas Commission order, correct?
At the bottom of page 11.
I'm sorry.
Yes.
I'm sorry, Mr. Hall, I didn't understand your question.
Let me restate it. I was just wanting, Mr. Ives, can you confirm that you are citing to an Arkansas Public Service Commission order in your testimony on this page?
At the bottom of page 11 on lines 19 and 20, I reference a couple of orders moving on to page 12, and Arkansas is one of them that's referenced on starting on line 19.
Thank you. Next, could you jump to page 35 of your SIR rebuttal testimony? Am I correct when I say that in the body of your answers and the footnotes, you are citing to a Michigan and South Dakota Public Utility Commission orders?
They are referred to on page 35 of my SIR rebuttal, yes.
Thank you. At this time, I would like to turn your attention to what Public Counsel has pre-marked as Exhibit 206. Is there a way to get that in front of you?
What is 206?
Arkansas. Counsel, is that the Arkansas Public Service Commission order?
Yes.
I have it.
Can you confirm that this is the same Arkansas order that you cited to in your direct testimony?
Yes.
Does this order from the Arkansas Public Service Commission contain a bad debt, a deferral of bad debt tracker similar to what has been included in the non-unanimous stipulation and agreement?
I'm reading it. I don't see that this order directly addresses that, unless I've missed it in my read-through.
Thank you, Mr. Ives. Could you next turn to Exhibit 207?
Council, that's the Michigan Public Service Commission order?
Yes, pardon me, I should have confirmed. Michigan Public Service Commission order.
I have the Michigan order.
Can you confirm that this is the same Michigan Public Service Commission order that you relied upon in your rebuttal testimony?
Yes.
Does this order contain a provision for the deferral of bad debt in the same manner as the stipulation that Evergy is supporting in this case?
So this order is rather lengthy. So based on my recollection, without reading the entirety of the Michigan order, I believe that the order provides for the opportunity for individual utilities to submit requests for deferral that could include those components, and they have to do that by, I think, the early part of November. So it creates the framework for those actions to be undertaken if I'm in the right state.
Okay. You generally agree then that it doesn't create a framework where the tracking and deferral of bad debts is based on whether bad debts are higher or lower than expected in 2021?
I don't believe it goes into the specifics of the framework. I think it gives the framework for utilities to request deferral in a separate individual utility filing.
Mr. Ives, could you next turn
by sometime in November?
Pardon me, Mr. Ives. I'm hearing myself through your speakers, so I get a little weirded out.
I'm sorry, I didn't get the end of his answer because there was I think you two talked on top of each other.
Mr. Ives appears to be frozen. We've lost.
I'm not frozen. I was waiting to see if there was a request to finish or clarify.
Mr. Ives, could you please repeat your answer for the court reporter?
I said I don't believe that this order goes into the specifics of how deferrals would be calculated, because it creates the framework for individual utilities in Michigan to file a request for deferral, and they would have to do that, I believe, by sometime in November of this year.
And Mr. Ives, could you next turn to Exhibit 208, which is the South Dakota Public Service Commission order? Let me know when you have it.
I have the South Dakota.
Similarly, can you confirm that this is the same South Dakota order that you relied upon for your Surrey rebuttal testimony?
It is.
And also similarly, do you agree that this order doesn't speak to the deferral of bad debt in the same manner as what Evergy is proposing in the stipulation agreement?
So this order does indicate that petitioners can include cost increases in addition to incremental bad debt in a regulatory asset, and if it does so, they would have to include cost increases. So I believe it does talk about incremental debt, but it does not give the specific mechanism in this order for the calculation.
For clarity, then, you agree with me then that this does not order the deferral of bad debt in the same manner as what is being proposed in paragraph 8, B, and C in the proposed stipulation agreement then?
Well, for clarity, I'm saying it does say that petitioners can defer incremental bad debt, but this order does not give a comparison or a calculation of how that is determined.
Great. I have no further questions. Thank you.
Is there any cross-examination from National Housing Trust?
I have no cross for the witness. Thank you.
Thank you. So I think the conference call line might want to mute. Okay, I am looking to see if Commissioner Roop is with us at this time. I think he had some questions for Mr. Ives. It is time for commissioner questions.
Yeah, Commissioner Roop's here.
Thank you, sir. Please go ahead.
No problem. Mr. Ives, the same question I asked earlier is, what's the difference in this stipulation than Spire and Missouri American Water?
Thanks for the question. I think there are two primary differences in the stipulation itself that I would point to, and one is those companies had some measure of addition into their stipulation for customer assistance programs. They're different between Missouri American Water's approach and Spire's approach, but they had something in there. Whereas our position, as Mr. Casely referred to and throughout our testimony indicates, is we made significant movements before we got to this point for putting $1 million into customer assistance programs across our territory, putting a total of another $1.2 million towards grants for communities and not-for-profit agencies. And we did significant outreach to customers, including the running of the 1 and 4 month incentive programs and the CSR discretion program that have been talked about earlier today. I don't know all of the details of those two utilities, but I don't believe that they had that level of commitment made prior to entering the agreements with the parties, that they had done voluntarily before that point. The second part that I would say is different in our stipulation from those two companies is the ability to evaluate bad debt expense impacts quarterly for 2 quarters following March 31st, when the remainder of the direct deferrals stop. That's the mechanism that says we'll evaluate quarterly, compare it against the amounts that are in rates, and to the extent that we are above or below the amounts in rates, 10% or greater, there would be amounts recorded to the deferral for potentially for that additional 6 months. Much like lost revenues were very important to several of the parties, as they've shared with the commission today. One, they were also very important to us, and we gave those up to get to this point. But the ability to continue to evaluate and make deferrals without further commission action was important to us, because there is such a long tail to addressing or ultimately getting to bad debt write-offs when you have suspended collections for a number of months. You have put 12-month payment plans in place, and then you also have cold weather rule impacts that preclude disconnections or movement towards bad debt expense. So the tail is so long, it makes a lot of sense to us for the deferral to be able to be considered in this 2-quarter tail month. And the parties that signed on to the agreement were able to work through that with us to put that into this non-unanimous agreement.
So isn't like Missouri American Water and Spire, aren't they in that same situation?
They are in that same situation. I suspect, my guess, and I can't speak to them, my guess is they don't have as many customers on 12-month payment plans right now that we do, because of the effort that we undertook to get people on those. I think gas certainly was in a different situation during the bulk of the shutdown period, because those were months that were typical higher electric usage months and lower gas usage months, just based on the season and the time of the year. So they may not have had quite the impact on lost revenues or on the arrearages, because their balances just wouldn't have been as high during that period.
Okay, thank you. That answered the 2 questions I had.
Okay, obviously the floor is open for additional commissioner questions. If we have any, I would ask the commissioners to speak up. I have some follow-up questions for Mr. Ives. I think that we have heard or will hear some argument in regard to the concept of materiality, which seems to be calculated looking at a 5% figure, perhaps, of net income or income. And my question for Mr. Ives would be, I know that there are some filings that are made by companies with the Public Service Commission and annual report, and also looks like a FERC Form 1 is sometimes included in that report. So if the commission is looking to figure out what the company's income is, where should the commission look? Should it be looking at FERC Form 1? Should it be looking at an annual report made to the commission? What would your recommendation be?
Yeah, so it might have been a better question for Mr. Clope, but I think I would point the commission to surveillance filings that are made by the jurisdictional utilities. I think those would provide the information that they'd be looking for. You know, just I have to reiterate because you asked the question. My testimony is pretty clear. It's our belief that materiality does not apply because that's a component of General Instruction 7. In General Instruction 7, it's very clear in the US of A, has nothing to do with the deferral of to regulatory assets or regulatory liabilities.
So if the commission is trying to figure out an income figure for the company, you mentioned surveillance filings. Does that include the annual report or a report made to FERC? Or is that something else?
They're specific to the jurisdictional utilities. They're required by us to be filed, and they would have the annual earnings for Missouri West and for Missouri Metro.
Are those annual filings? Or are they made on a quarterly basis or?
Well, interestingly, we make surveillance filings, I believe, monthly, quarterly, and annually for different purposes, but there would be an annual filing.
Okay. So I believe the company would have filed something with the SEC as far as a third quarter report goes to report something ending September 30th, 2020. Are you familiar with that?
Yes, I was responsible for those filings for the first 14 years of my career at Evergy, but yes, we file quarterly with the SEC.
Okay.
I would suggest that SEC filings are not in all cases consistent with jurisdictional filings, both because there are non-jurisdictional impacts in the SEC reports. There are also differences between amounts that are recorded for SEC or GAAP financial purposes and for FERC purposes. And we don't file an SEC report that is specific to Missouri West. And we do file a Evergy Metro report, but it's not broken down between Missouri Metro and Kansas Metro. So I think the surveillance reports would be a much more relevant resource than the SEC reports.
Okay, so are you saying that an SEC filing ending September 30th of 2020, if it's providing an income figure of some kind, you're saying because that the way that's reported, it's not possible to separate out an exact figure for Missouri West or Missouri Metro?
That's correct.
Okay. Do you have a calculation at hand of the COVID-related costs that Evergy has incurred through the end of September?
I do. I just have to put my hands on it.
And this would be either, I guess, the best information would be for each company, but I don't know if you have that.
I think I have what you're looking for here.
Okay.
So are you looking in total for amounts that would be eligible by company at this point in time? I would have through September.
Yeah, I think it would be helpful to know what those numbers would be through September. that would be eligible for deferral based on the company's present request?
I have a sheet. I'm pausing because I have a sheet that is easier for me to follow than the ones that I found. I'm not sure why I'm not finding it. So I'll start with Missouri West. And Missouri West, if I'm looking at this right, for cost eligible for deferral net of the identified savings or offsets would be about between 1.4 and 1.5 million for the period from when we said the beginning of March or whatever that March date was that we agreed upon through the end of September.
Okay. And that is a figure where you indicated you had already netted any savings against that to reach that conclusion.
That is correct.
And that was for Missouri West.
That's correct.
Okay. Did you have a Metro figure?
And yeah, for Missouri Metro, I'm doing a little math in my head here. It looks to me to be about $2 million. And that would be the cost to be deferred netted with cost available for offset due to savings.
And these are both through end of September, is that right?
Yes, end of September, which, I just remind everybody that, we didn't do any disconnections at all until mid-July, as Mr. Casey called for, and we've got, Evergy-wide, we've put over 100,000 customers on payment plans now. The majority of those are 12-month payment plans, and there certainly wouldn't be any bad debt expense impact from folks that are on plans and continue to participate on them. So there's not much impact in bad debts at this stage of the process.
Okay, I'm sorry for interrupting you, sir. I have another question for you. Is it the availability of this 12-month payment plan that's been offered to customers? Is that where the request comes to have this extended treatment of bad debt? Are those things related?
Yes, absolutely. I mean, to be clear, our filed position and position up until the settlement was that there shouldn't be a stoppage or a cutoff in the deferral period because we just don't know the length of time that our service territory and our customers, our company are going to be impacted by the effects of COVID. But in the settlement, we agreed to this extension, and it's precisely that. There's such a tail on a 12-month payment program that we don't expect that we will see the effects of non-payment of customers that are on those payment plans until much later than where we are today. If we see non-payment, hopefully the payment plans will help those customers to be able to stay current and work through the process. No problems.
Okay, thank you. So I'm going to ask you about something that is mentioned in an OPC witness's testimony, Dr. Mark. He refers to some apparently public statements made by Evergy folks in regard to a sustainability transformation plan and some savings in operation and maintenance costs. Does that sound familiar to you?
It sounds familiar, yes.
So there is apparently a report there of a certain amount of operations and maintenance savings that the overall company has experienced. So the question for you is, in apparently a relevant period of time in relation to COVID, is there a reason why you would contend the commission shouldn't consider that kind of savings and operation and maintenance costs when it's considering this AAO application or deferral of costs in general?
Yes, there is. This particular application addresses the effects of COVID-19, both costs attributable to the impacts of COVID-19, as well as cost savings that are being realized with a reasonable nexus to COVID-19. There was testimony earlier today, or maybe discussion at least, that we have been under cost-saving initiatives really since 2018 as a result of our merger between the legacy Great Plains Energy and Westar Energy in Kansas, which created Evergy. Merger savings that were discussed and talked about and contemplated as a part of that combination. Moving from there, we have announced, as Dr. Mark refers to, STP, or Sustainability Transformation Plan, that is our next 5-year plan for the years 2020 through 2024. That plan has a number of initiatives in it, both from an investment and from a cost saving standpoint. None of the items related to the merger and none of the items related to the STP have any direct nexus to COVID-19 and aren't part of the content of this proceeding. And I think there was referral earlier on to a footnote on maybe like page 3 of the non-unanimous stipulation that indicates that the parties acknowledge that those type of activities are not part of what's being considered in these savings.
Okay, those are all the questions I had for you, sir. Once again, if commissioners have questions, please speak up now. So we can go to recross then, if anyone has any recrossed staff. Did you have any questions?
No, Judge.
And Missouri Industrial Energy Consumers, Ms. Plesha.
No questions, Judge. Thank you.
And Midwest Energy Consumers Group.
No, thank you.
Sierra Club.
No questions, Your Honor.
Renew Missouri.
No, thank you, Judge.
And Office of the Public Counsel.
No questions, thank you.
National Housing Trust.
Thank you. No questions, Judge.
All right, thank you very much. Any redirects for Mr. Ives from Evergy?
Yes, Judge. Mr. Ives, just to confirm the footnote that you talked about, am I correct? That's the footnote at the bottom of page 3 of the non-unanimous stipulation agreement, which is marked as footnote 1. Is that correct?
That's correct. Yes, footnote 1 at the bottom of page 3.
Okay. Let me ask you, if I could, to turn to the Michigan Public Service Commission order that Mr. Hall asked you about. It's been marked as Exhibit 207.
I have it.
Okay. Would you please turn to page 20 of that order?
I'm there.
And with regard to this section that begins reply comments, is it generally correct that in the reply comments that are on page 22, 2 pages later, in the first full paragraph, that the staff of the Michigan Public Service Commission recommended that the commission refrain from setting a termination date for tracking and deferring uncollectible expenses. Is that correct?
Yes, it specifically says that the commission refrained from setting a termination date for tracking and deferring uncollectible expenses and approve the continued tracking of certain COVID-19 related costs as well as foregone revenues. And then the next sentence is what I referred to, where they suggested that utilities seeking deferral of related expenses make an informational filing by November 2nd, describing the expenses, foregone revenues, uncollectibles, things that may be approved for deferred accounting treatment.
And in that description, does that include bad debt, as you were questioned by Mr. Hall with regard to?
Yeah, and that staff recommendation, it talks about that informational filing, including uncollectibles to be approved for deferral accounting treatment.
If you would turn to page 30 of the Michigan order, in the middle of that page, there is a category that is entitled cost slash, the marking slash, not the word slash, but it says cost slash foregone revenue category. Do you see that, sir?
I do.
And does that appear to give utilities the opportunity to list both the costs that they have incurred and the revenues that they have foregone in a proposal to present to the Michigan Commission?
It does. That section on page 30 is saying for each cost or revenue item that they seek to defer, their filing should contain the following information for calendar year 2020. And it talks about a narrative for cost or foregone revenues that they're requesting. It also asks for the cost included in rates for each month related to those.
Now, if you would go to page 32 and 33 to the section that is entitled savings. Do you see that, Mr. Ives?
I do, in the middle of the page.
Correct. And on the next page, at the bottom, in response to various recommendations, do you see where the commission notes that it is a creature of statute and as such is limited in its authority to direct utility management decisions?
It does. It's talking, the lead into that sentence was talking about recommendations that were made to direct utilities to pursue specific cost-saving measures.
And in your experience as the Director of Regulatory Affairs, does Missouri and this commission in particular follow similar principles with regard to the role of the Public Service Commission?
In terms of being a creature of statute and limited in their ability to direct utility management decisions, I do believe the commission
Objection, calls for
adheres
legal
to that.
conclusion.
Your Honor, my response would be that Mr. Paul has opened the door with regard to asking this witness to respond to regulatory and legal concepts in here, and in his capacity, not as a lawyer, but as the Vice President of Regulatory Affairs, he is certainly qualified to render his testimony with regard to whether the commission has been treated as a creature of statute, not only by Missouri courts, but by itself and the decisions that it has rendered.
For what it's worth, I will hear Mr. Ives' answer in regard to a parallel in these two states' regulatory structures, given that Mr. Hall did ask the commission to look at these other states' decisions.
And finally, Mr. Ives, if I could ask you to turn to page 44 of the Michigan order, to the section on customer protections and affordability. Do you see that, sir?
I do. Starts in the middle of page 44.
Right. And am I correct that at the bottom of the page, with respect to recommendations made by other parties, the commission stated that certain comments were beyond the scope of this proceeding? Is that correct?
That's correct. The first paragraph talks about the central theme of comments and lists several. And then in the second paragraph, the commission says that some recommendations provided in comments are beyond the scope of the proceeding, outside the authority of the commission to carry out within an order, or are already being addressed by energy providers.
Thank you. Can I ask you to turn to Exhibit 206, which is the Arkansas order that Mr. Hall asked you about?
I have it.
Okay. Am I correct, or pardon me, is it correct if you directing your attention to the first paragraph of the order that the Arkansas Commission concluded at the end of that paragraph that COVID-19 was a public health emergency?
Yeah, I think the commission refers to it. I think it's referring to an executive order by the governor.
Now, with respect to the Arkansas Commission's encouragement to utilities to offer reasonable payments, is that dealt with in paragraph 4 of this order?
It is. It's a very high-level statement. It just indicates that the commission encourages utilities to offer reasonable payment arrangements once the prohibition on disconnections is lifted.
And have the Evergy companies done that?
We have the 1 month, the 4 month, the 12 month. We've worked hard.
Now, directing your attention to the next page, paragraph 9 of the Arkansas order, what does that paragraph provide with regard to utility customers paying their utility bills?
Yeah, that paragraph 9 indicates that from the commission that this order that they're providing does not eliminate the requirement that utility customers continue to pay utility bills during the temporary suspension. It goes on to state that customers should continue paying their bills and understand that they will ultimately be responsible for utility services accrued during the suspension.
And finally, with regard to this Arkansas order, Mr. Hall asked you about bad debt provisions. Is there anything that you found in this order that prohibits or criticizes companies from requesting the kind of treatment for bad debt or uncollectible expense as is requested in the non-unanimous stipulation and agreement?
There is nothing in this order that prohibits that.
And specifically in the second sentence in paragraph 3, which is on page 3, does the commission authorize the utilities to establish regulatory assets to record costs resulting from suspension of disconnections?
It does. It does, and then it talks about the future proceedings where the commission will consider the utility's request for recovery of reg assets and appropriate recovery period, amount of carrying costs thereon, and savings attributable and other matters.
And would that include bad debt?
I think you could, I think you could certainly take from that bad debts would be eligible to be considered. And then finally, let me ask you to turn to Exhibit 208, which is the order issued by the South Dakota Public Utilities Commission. I've got it. Okay. And directing your attention to paragraph 4 of that order, does it state that the commission staff of the South Dakota PUC had recommended approval of the deferral request subject to conditions contained in a staff memorandum dated August 12, 2020? It does state that.
Okay. Now, do you have a copy of what I believe we have served upon all the parties marked as Exhibit 10, which is entitled Staff Memorandum?
I do have the staff memorandum.
And does it indicate in the Ray clause that it was submitted in docket number GE 20-002?
Mr. Zobrist, I do not have a copy of this Exhibit 10.
I apologize for that. I thought that Mr. Westenkirchner had emailed that to all parties a couple of hours ago.
Yeah, this morning.
Sierra Club received it.
Oh, Mr. Zobrist, my apologies for the interruption. I have it now.
Okay. And understanding, Mr. Hall, I presume you have not had an opportunity to review this?
No, Mr. Zobrist, you may proceed.
Mr. Ives, based upon your review of the South Dakota PUC Order Exhibit 208, does Exhibit 10, entitled Staff Memorandum, in the same docket number appear to be the staff memorandum whose conditions were adopted by the South Dakota Commission in its order?
Yes, yes, it does.
And if I would ask you, please, to turn to page 5 of the South Dakota Staff Memorandum. Does that set forth the accounting authority under which the deferral was granted by the South Dakota Commission?
Yes, on page 5, it does.
Okay. And how does that relate to General Instruction 7 that's been cited by a number of the parties in this case?
Yeah, so the authority cited by this staff in this docket references ASC 980, which is a financial accounting standard that is very similar to definition 31 of the US of A and the definitions for regulatory asset and liability counts 182.3 and 254. It doesn't relate at all to General Instruction 7 of the US of A.
And US of A is the Uniform System of Accounts that's been promulgated by FERC and the Code of Federal Regulations and adopted by this commission?
That's correct.
Judge, I have nothing further.
Thank you very much. Okay, that concludes Mr. Ives' testimony at this time. Thank you, sir. So I believe where that puts us is ready to move on to Sierra Club's witness. We will Assuming that's going to work for you, Ms. Henry?
That works for Sierra Club, yes.
Okay, so is a 15-minute break going to be adequate, or do we need a longer break? Okay, we're going to,
I failed to offer Exhibit 10, and I would also like to offer Exhibits 206, 207, and 208 into evidence.
so Exhibit 10 was the document that was distributed this morning by Evergy by email, and it is the staff memorandum out of South Dakota. Is that right?
That's correct.
Is there any objection to that exhibit being included on the record? Hearing no objection, Exhibit 10 will be admitted. And then Mr. Zobrist, I believe that's who I'm hearing from.
Yes,
Did
ma'am.
you? Did
And
you?
the other,
Are you also offering some exhibits that were marked by OPC?
yes, Judge. Exhibit 206, the Arkansas Commission Order. Exhibit 207, the Michigan Commission Order. And Exhibit 208, the South Dakota Commission Order.
Is there any objection to those three exhibits, which are orders out of other states' utility commissions, being admitted to the record in this case? So there are no objections. Exhibits 206, 207, and 208 will be admitted.
Thank you, Judge.
So as I said, we were going to come back, and I'm going to set that return time at 3:35, and we will come back with Sierra Club's witness. So we are now in recess and off the record. Thank you.
Judge, if I could ask just a minute, since we're off the record, how long do you expect to hold proceedings today? I just got a message we may have a witness availability this issue later on this evening.
So I was not planning to go late into the night, if that's what you're asking. How late were you all planning on going?
I didn't expect this till past 5, but I also didn't want to presume anything, so that's why I just asked now.
That's good. That's always good to not presume. Yes, I am planning on eating dinner with my child tonight. So she usually eats at about 6 o'clock. So that's what we will plan to do since we scheduled a 2-day hearing. I hope that works for everybody. Okay, I will see you all back here at 3:35. Thank you so much. Ms. Bench, do you need anything?
Hope I'm good.
Okay, good. Thank you.
Uh-huh.
Justin, can you confirm everything's okay on IT's end?
Yeah, everything is good on my end.
Thank you. All right, it's 3:34, so we'll be getting going here in just a minute, everyone.
Should we have Ms. Roberto check her technology and make sure it works?
That's a good idea. I can see Ms. Roberto. If you'd like to speak up, we'll see if we can hear you.
Good afternoon. Can you hear me, Your Honor?
I can, but you're very quiet. Want to move your microphone? Do you have a mic on your headset?
I do.
Okay, yeah. It might need to
better?
maybe adjust it so it's closer to your mouth.
How's that?
It's better.
I don't know what's happening with it. How about that?
That's much better.
Okay.
Thank you. Is that going to work for you, Ms. Bench? Okay. All right. So it is 3:35 right now. We are going to get back on the record. We're now on the record once again. So I did ask for a little time from the parties to let me take a look at the passage that OPC was concerned about in the exhibit offered by Evergy, Mr. Ives' testimony, the confidential and public versions, and those are Evergy exhibits 8 and 9. Counsel for OPC was objected to these exhibits based on a passage at page 11, lines 13 through 20. I've taken a look at that. The objection was a hearsay objection. So I don't think there is any risk that the commission is going to be led astray by this passage. I think the evidence is competent. I am going to overrule the hearsay objection. Whatever credibility problems there are with this passage are clear on its face. Basically, Mr. Ives is just giving his opinion and then trying to persuade the commission that other people agree with him. Comes close to providing an out-of-court statement there, but there technically isn't really an out-of-court statement expressed there. So I don't see a hearsay problem. So exhibits 8 and 9 will be admitted to the record.
Judge, if I could be heard just briefly further, in framing my argument, I didn't have the statute in mind, but the statute that I would quote is section 490.065 of the Missouri Revised Statutes, and that does allow this type of opinion testimony to come in and deals with a potential hearsay problem. But
so you agree with me? Yeah, you agree with me, Mr. Zobrist, that there is not a problem and that this should be on the record. So those have been admitted.
I'm sorry, I thought. Okay, great. Thank you. Yes.
Okay, thank you. All right, so the next thing that we were getting ready to do was we were going to hear from Ms. Roberto. So I believe what we can do is if she is ready to go, we can get her sworn in. And she has conveniently raised her right hand for us. Ms. Henry, are you ready to go?
I'm ready.
Okay.
I'd like to call Ms. Roberto to the stand.
Thank you so much. Ms. Roberto, and is it Roberto? I apologize.
I answer to either. Thank you, Your Honor.
Okay, well, you can introduce yourself after we've sworn you in, and then I'll try to pay attention to that. So, do you solemnly swear or affirm that the testimony you're about to give in this hearing will be the truth, ma'am?
I do. Thank you.
Thank you. You may proceed. Thanks.
Good afternoon. Can you please state and spell your name for the record?
My name is Cheryl Roberto, Cheryl, Roberto, Roberto.
And Ms. Roberto, can you please tell us by whom you are employed?
Synapse Energy Economics.
And what position do you hold?
I'm a senior principal.
And can you briefly describe your educational background?
I'm a lawyer by training.
And can you please describe your employment history?
Yes, I'm a former commissioner on the Ohio Public Utilities Commission. Prior to that, I was a director of public utilities for the 15th largest municipality in the United States. Subsequent to my service on the commission, I ran the Environmental Defense Fund's Clean Energy Program, and I currently now work for Synapse Energy Economics.
And have you testified before this commission before?
I have. Oh, no, only this matter. Thank you.
And have you testified before other public service commissions?
Yes, I have.
And have your credentials been accepted by other commissions?
Yes, they have.
And would you list which other commissions you have testified before?
Let's see, Maryland, Indiana, Colorado, Arizona, Ohio. I've appeared before FERC and the U.S. Senate.
Thank you. And you have served as a commissioner for a state utility commission?
Yes, I did.
And are you the same Ms. Roberto who submitted rebuttal testimony in this proceeding on August 17th, 2020 that has been marked for identification as Exhibit 500?
Yes.
And what's the purpose of your rebuttal testimony?
Sierra Club retained me to assess the application by Evergy for lost revenue recovery as a regulatory asset.
And do you have any changes or revisions to your rebuttal testimony?
I do not.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
I now offer Exhibit 500 and tender Ms. Roberto for cross.
I had to adjust my headset and fix something. Have I missed something that you, I apologize.
I offered Exhibit 500 and I tendered Ms. Roberto for cross.
I apologize, Ms. Henry. It was very bad timing on my part. Okay, so Ms. Henry has offered Ms. Cheryl Roberto's rebuttal testimony, which is marked as Exhibit 500. Are there any objections? Hearing no objections, Exhibit 500 is admitted to the record. Okay, so we can proceed with any cross-examination. Does Evergy have any cross-examination?
Questions, Judge? I say it again. No questions, Judge.
Thank you. And I believe staff would be up next. Any questions from staff?
No questions, Judge.
And Missouri Industrial Energy Consumers?
No questions.
Midwest Energy Consumers Group?
No, thank you.
And Renew Missouri?
No, thank you, Judge.
Office of the Public Counsel?
Yes, thank you, Judge. Good afternoon, Ms. Roberto.
Good afternoon.
Ms. Roberto, are you familiar with a group commonly referred to as NARUC?
Yes, sir.
What is that group?
It is the National Association for Regulatory Utility Commissioners.
And weren't you invited to speak at a NARUC function this week?
No,
Was it last week?
I actually spoke at Nasuka this week, and I have not spoken at NARUC this year.
Thank you. My mistake. What is NASUCA?
That's the National Association of Consumer Advocates.
And what was the NASUCA function you spoke at?
It was the annual meeting.
And what did you speak on?
I had a 15-minute vignette talking about lost revenue recovery for COVID.
Do you recall speaking on Evergy's earnings during your talk?
I did.
Did you speak on Evergy's second financial quarter earnings for this year?
I did. I referenced the same information that I filed in my testimony.
And how do Evergy's second financial quarter earnings for this year compare to last year?
They were better in the second quarter of 2020 than they were in the second quarter of 2019.
And this increase has happened even with the rise of COVID-19.
COVID happened, yes, in 2020.
Thank you. Ms. Roberto, your counsel mentioned that you were a former public service commissioner. In what state were you a commissioner?
The state of Ohio.
For how long?
1 term.
How long is a term in Ohio?
It's 5 years.
And so your experience on the Ohio Commission informs your testimony today.
Yes.
No further questions. Thank you.
Thank you.
Do we have any questions from National Housing Trust?
I have no questions for the witness. Thank you, Judge.
Okay, so it looks like we would be ready for any questions from the commission. Are there any commissioner questions? Okay. So I have a question. Apparently, Ms. Roberto, you have addressed a consumer advocacy group in regard to Evergy's second quarter earnings. Was that right, for 2020? Is that accurate?
Your Honor, I addressed a consumer advocate organization. The larger topic was how are commissions looking at lost revenue recovery?
Right. And
yes.
Okay. And because you had submitted testimony in this case, you had some stuff to say about that. Apparently, you provided opinions on that topic in other cases.
I have also testified in Indiana.
Okay. So did you look at third quarter earnings at all? I'm just wondering, since those would have been available.
No, I did not.
Okay. All right. So that was all I was wondering. And I'm not seeing any additional questions. I don't see anything in my email indicating someone's trying to get in. So if there's any recross, we can go to that if Evergy had anything they wanted to ask. What I'm going to do here, instead of doing a roll call, is ask the parties if they would like to engage in recross. So
No further questions from Evergy.
thank you. And Ms. Myers is indicating no for staff. Ms. Plesha has not indicated anything. Midwest Energy Consumers Group, I cannot see Mr. Woodsmall's face.
No, Your Honor.
Thank you. Renew Missouri does not look like Mr. Opitz wants to ask any questions. Office of Public Counsel, did you have anything else?
None further. Thank you.
Thank you so much. And National Housing Trust.
No, none, Judge. Thank you.
Okay. And any redirect from Sierra Club?
No redirect, Your Honor.
Okay. Well, Ms. Roberto, I would like to apologize to you. I have been paying close attention today. I just had to deal with something very quickly. So I apologize for that. And I appreciate your appearing here today. Thank you so much. That will conclude your testimony.
Thank you, Your Honor.
Judge?
Yes.
I just had a quick question. I couldn't distinguish if it was Mr. Zobrist or Mr. Hack that was answering for Evergy.
It was Carl Zobrist.
Thank you.
Okay, so according to my outline, that should put us at staff's witnesses. So that's where we are right now. Ms. Myers, are you ready to go with witnesses?
Yes, Judge, and we would call Kim Bolin.
Okay, thank you so much.
And we can check and see if Ms. Bolin's video is working and audio.
I do see Ms. Bolin here. Go ahead, ma'am.
Can you hear me?
Yes, we can.
Okay.
Okay.
So, Ms. Myers, is it okay if I just swear Ms. Bolin in first here and then I'll hand her off to you? Okay.
Yes.
Ms. Bolin, do you want to raise your right hand? All right. Do you solemnly swear or affirm that the testimony you will give in this hearing today will be the truth, ma'am?
I do.
Thank you so much.
All right. Ms. Bolin, please state your full name for the record.
My name is Kimberly Bolin, and Bolin is spelled B-O-L-I-N.
Thank you. Where are you unemployed and in what capacity?
I am employed by the Missouri Public Service Commission as a utility regulatory manager.
Are you the same Kim Bolin who prepared or caused to be prepared the testimony that's been marked as Staff Exhibit 100, both public and confidential?
Yes, I am.
Do you have anything you wish to correct in that testimony?
Yes, on page 3 of my rebuttal testimony, on line 17, I wish to remove the words "in excess of" and replace them with "up to the." So the sentence should read, "waived late payment fees up to the amounts included in the cost of service established in the most current rate case."
And Ms. Bolin, is this correction to both your public and confidential versions?
Yes, it is.
And court reporter, did you get that correction? I believe so. Okay. Now, with that in mind, Ms. Bolin, if I asked you these same questions today, would your answers be the same?
Yes, they would.
And so is the information in these documents true and correct to the best of your knowledge and belief?
Yes, they are.
All right, Your Honor, staff would offer Exhibit 100, both public and confidential, and tenders Ms. Bolin for cross.
Okay, so I have to check with you to confirm if the corrections are in the exhibits that were provided to me earlier this week, or if there's a new.
They were not. So
Okay.
The exhibits were just those that are filed in EFIS. There's been a correction to
Okay.
them. So if you would like us to recirculate a corrected version, we can do that.
Well, we will have to do that at some point in order to make sure the right one gets filed. It sounds like the parties at least would have seen that.
We will
Corrected
circulate
version?
it to everyone.
Okay. All right. So I think what we can do then is a corrected version as described by Ms. Bolin is going to be circulated. Are there any objections to staff's Exhibit 100, the corrected version being admitted to the record in this case? And hearing no objections, the corrected versions of both the public and confidential rebuttal testimony of Ms. Bolin will be admitted to the record. We will talk later about how to make sure that those get marked and filed. Thank you. And you can proceed, Ms. Myers.
Oh, I tendered the witness for cross-exam.
Oh, I'm sorry.
Okay.
So is there any cross-examination from Evergy for Ms. Bolin?
Just a few questions, Judge.
And we are hearing
good
from Mr. Hack or?
This is Carl Zobrist.
Okay, thank you. Please proceed.
Ms. Bolin, looking at page 6 of your rebuttal testimony, you stated that COVID-19 has changed the way many people live and work and appears to have had significant financial and operating impacts on utilities. Is that correct?
That is correct.
And is that your opinion today?
Yes, it is.
And you stated later on that page, on lines 7 and 8, that it is unknown what the financial incremental costs, revenues, and/or savings incurred will be as the COVID-19 pandemic continues for an indefinite period of time. Is that still your opinion today?
Yes, it is.
And is it your opinion that at the present time, no one really knows when the pandemic is going to end?
That is correct.
And so therefore, the financial impacts that you describe here on page 6 may continue for an indefinite period of time.
That is correct.
Do you have a copy of Exhibit 1, the non-unanimous stipulation and agreement before you?
Yes, I do.
I just have a series of general questions about it. If you could turn to Section 2. Am I correct that subsections A through D set forth the 4 categories of costs to be deferred?
Yes, it does.
And that also includes the savings that may be incurred by Evergy as well, correct?
I believe the savings are listed on paragraph 7, page 3 and 4.
And so to the extent there are savings related to things like customer assistance programs, the various payment plans, the 12-month plan, am I correct that those will be offset by savings that occur in other areas of the company that are related to COVID-19?
That is correct.
Okay. And let me just ask you about the deferral periods. Am I correct that there are 2 deferral periods that are contained within the stipulation?
Yes, there are.
Okay. So the first or primary AAO is to begin March 20th, 2020, and if approved, go through March 31st, 2021 for a period of 13 months. And that's in paragraph 8.
I have the deferral beginning March 4th, 2020 and going through March 31st, 2021.
That's correct. And if I misspoke, you spoke correctly. And that's roughly for about an additional month than what staff's proposal was in your rebuttal, which was to end in February 28th, 2021. Is that correct?
That is correct.
And it's also much shorter than the period of deferral that Evergy initially proposed. Is that correct?
That is correct.
Now, the deferral of the bad debt expense, the secondary AAO, would continue for 2 more quarters if approved by the commission. Is that correct?
Yes, it would go from April 1st, 2021 through September 30th, 2021.
Okay. And this, again, applies to both costs and cost reductions. Is that correct?
This goes only for uncollectible expense.
But are cost reductions also part of that? Oh, no, they're not. That's right. Never mind. Yeah, this just simply deals with the comparison of bad debt today versus the bad debt that's in rates, correct?
That is correct.
And am I correct that staff reviewed the data that is contained in Exhibit 1 to this stipulation and agrees with the numbers regarding the bad debt expense set forth for both Evergy Metro and Evergy Missouri West?
Yes, I personally review these numbers.
Okay. And so the provision of this second AAO relates to actual net write-offs per quarter, whether they exceed the net write-offs in the last rate case by 10%, or if the net write-offs in the last general case exceed the actual net write-offs by quarter by 10%. Is that correct?
That is correct.
So it's a two-way concept. Is that correct?
Yes, if it exceeds 10%, it will be included in the deferral, and if it is under 10% of what was based into the rates, it will be as an offset to the deferral.
Okay. And as an offset, it would therefore reduce their deferral.
Correct.
Okay. And is it also true that the stipulation contains provisions that allow for the extension, renewal of both the primary AAO as well as this secondary AAO?
Yes, there's provision that if the parties agree or commission order can be ordered to extend the deferral period.
And am I correct that overall the staff supports the provisions in the non-unanimous stipulation and agreement and requests that the commission approve it?
Yes.
And staff's opinion is that this, if approved, it would be a just and reasonable outcome. Is that your opinion?
Yes.
Okay. Nothing further, Judge.
Thank you. Do we have any cross-examination from Missouri Industrial Energy Consumers? No? Okay.
Thank you, Judge.
Thank you. And Midwest Energy Consumers Group?
No questions. Thank you.
Thank you. Sierra Club, do you have any questions?
No questions from Sierra Club, Your Honor.
Thank you. Renew Missouri, any questions?
No, thank you, Judge.
And Office of the Public Counsel, Mr. Hall, do you have any questions?
Yes, briefly. Ms. Bowling, good afternoon.
Good afternoon.
Are you familiar with the Commission's cold weather rule?
I am somewhat familiar with it, yes.
Can you speak to what a customer's payment arrangements are if they qualify for the cold weather rule?
I could not do that. I don't know the details to the cold weather rule.
Which staff witness on the agenda should I direct those questions to?
I'm going to guess it would be Natel Dietrich.
Thank you. No further questions.
Okay, thank you. And National Housing Trust?
I have no questions. Thank you.
Thanks. So we're up to possible questions for Ms. Bolin from the Commission. Do we have any Commissioner questions at this time? Let me check my email. I don't have any pending questions. I would like to ask Ms. Bolin, if you were trying to figure out Evergy's net income or income for the year, are there any specific filings with the Commission that you would look at?
Yes, you could look at the most recent rate case that was on file, the accounting schedules to that. It was a couple of years ago. I don't think it'd be too outdated. Or you possibly could look at the quarterly FAC surveillance filings that are filed with the Commission.
Okay, and are those the surveillance reports that were referred to by an Evergy witness earlier today? I don't know if you observed that testimony or not.
I believe they are the same ones that Darren Ives was talking about.
Okay, and so those are something that might be called a surveillance report?
Yes.
And now your testimony is telling us that those are related to the FAC?
Yes, they're called FAC quarterly surveillance reports.
Okay. And are those confidential filings?
I am not sure on that. Yes, they are. It appears they are confidential. I'm sorry.
Okay.
Looking at EFIS right now. Yes, they are confidential.
Okay. Is the annual report filed with the Commission of any use as far as income goes?
You could use it. You'd have to sort through some of the data, but it possibly could be used.
And when I went looking around EFIS, I noticed something called FERC Form 1, which obviously the PSC is not FERC, but there it was FERC Form 1. Is that useful if that's filed with the Commission?
That would contain both Missouri and Kansas information. It would probably be best to look at Missouri only information.
Okay. All right, and then I'm going to ask you about the different measures that Evergy has taken for their customers in this situation in response to COVID. Is it staff's position that all of those measures are eligible for deferral at this time, or are there parts of that program that are not under the agreement?
Real familiar with the programs, but we did agree to what is stated in the stipulation about all the programs except for the ones identified in paragraph 17.
Okay.
That question may be better related to Ms. Dietrich.
Thank you. I'm consulting one more thing to figure out if I have another question for you. So thank you for being patient with me. I presume that it would be accurate that staff's position is that any of the pandemic-related savings that should be booked against a regulatory liability are those items that are specified in the agreement?
Yes, they are specified. They're listed from on page 3A through H.
Okay. And is it accurate that staff has not recommended that a catch-all category be included for other incremental costs or savings? So is it understood under the agreement that all of the possible costs or savings have been identified pretty clearly by category?
I believe they have been by category.
Okay. I don't have any other questions for Ms. Bolin. Once again, the floor is open for any commissioner questions. All right, so that brings us to recross. And Evergy could ask questions if they wanted to.
Judge Evergy has no questions.
Thank you. Missouri Industrial Energy Consumers.
Yes, I do have a question. Good afternoon, Ms. Bolin.
Good afternoon.
The judge was asking you about sources of information that would yield, well, the best sources to find out the company's income. And you talked about the company's annual report. You talked about surveillance reports, FERC Form 1. In your opinion, which of the sources that you mentioned would be the best source to find out the company's income?
I think in this case, it would be the most recent accounting schedules that were in the last filed rate case. Those are adjusted for rate making purposes. The surveillance is just raw data that has not removed or added things that we would normally do in rate making.
Thank you. No further questions.
Do we have any recross from Midwest Energy Consumers Group?
No, Your Honor.
Thank you. And Sierra Club?
No, Your Honor.
I think I'm getting a negative from Sierra Club. Renew Missouri?
I'm sorry, that was a negative, Your Honor, yes.
Okay,
No, thank you, Judge.
thanks. Office of the Public Counsel, did you have any recross?
Just real quick again, Ms. Bolin, you're referring to, in response to commission questions, you're referring to accounting schedules in a former rate case. Are these schedules attached to particular staff witness testimony? What is the nature of this filing?
Those were the staff accounting schedules filed in case number ER 2018-0145 and 0146.
Do you know if it's a separate filing or is this attached to witness testimony?
In that case, it was a separate filing. As in most cases, the accounting schedules are a separate filing.
Thank you. No further questions.
And I think I'm going to have to ask a follow-up question just to understand, because I'm having a hard time understanding how accounting schedules from a past rate case are going to help us figure out current or recent income for the company. So how would that work?
In this case, it's been maybe 2 years since that last case. So I think the data would be fairly up to date. And the data used for the accounting schedules would reflect all of the rate making normalizations and annualizations that go on during the rate case. The data from the FHC filings is more just pure raw data and has not been annualized, normalized like we do in rate making procedures.
So would it theoretically be possible to take that surveillance reports and perform some of those procedures or calculations to annualize and normalize and do those technical things that you just mentioned?
That would consist of a whole rate case. There's
Okay.
stuff that goes on there.
There was a newbie question if you ever heard one. Okay, so National Housing Trust, did you have any questions for Ms. Bolin?
No, thank you, Your Honor.
Okay, Ms. Myers, did you have any redirect?
Briefly, Judge. And I won't belabor the point, but Ms. Mullen, you've been asked several questions about accounting schedules. And from my understanding of what you're suggesting is that you can look at the accounting schedules from the last rate case, ER 2018-0145 and 0146. And then a good comparison would be in Evergy's next rate case, which they will be filing as commented earlier in early 2022, the accounting schedules in that case, and then making a comparison there would be a good comparison.
That might work, yes.
Mm-hmm. And also to I guess dive into your testimony, you talked about how you know, an authorization of an AAO or a deferral is not a guarantee recovery, correct?
That is correct.
And so what does staff look at then if something is costs or savings are authorized to be deferred? Do we then look at those costs in a rate case?
Yes, we do.
All right. Well, thank you, Ms. Pullen. That's all I have.
Thank you very much, Ms. Bullen. That will conclude your testimony at this time. And did you want to call your next witness now, Ms. Myers?
Yes, Judge. We would call staff witness Byron Murray. And Byron, is your camera and audio working? I know I saw him on here earlier.
Yeah, he was on here bright and early.
Yes. Taking a quick look. I see you. Byron, I can see your name. Are you able to do video at all?
Yes, I just had to unmute the computer there. I'm here. Go right ahead.
Hello there. Good afternoon. All right, Judge. Staff would call Byron Murray.
Thank you very much. Mr. Murray, would you please raise your right hand, sir? Do you solemnly swear or affirm that the testimony you'll give in this hearing will be the truth?
Yes.
I couldn't hear you.
Yes.
Okay, thank you, sir. You may proceed.
Good afternoon, Mr. Murray. Could you please state your full name for the record?
Byron Murray, Murray.
And Mr. Murray, where are you employed and in what capacity?
Public Service Commission staff as an economist.
Are you the same Byron Murray who prepared or caused to be prepared the staff rebuttal testimony that's been marked as Exhibit 101?
Yes.
Do you have anything you wish to correct in that testimony? I'm sorry, Byron, if you responded, I couldn't hear you. Do you have any corrections?
No.
Okay, thank you.
No, I don't. Thank you.
With that in mind, if I asked you these same questions today, would your answers be the same?
Yes, they would.
Okay.
Yes,
And so is
they
the
would.
information, sorry, is the information in that document true and correct to the best of your knowledge and belief?
Yes, it is.
Okay. Your Honor, staff offers staff exhibit 101 and tenders Mr. Murray for cross.
So, Ms. Myers, this is Rob Hack. I don't have any questions for Mr. Murray, but I was having difficulty understanding his responses because I think there might be a bandwidth issue. So I wonder, just trying to be constructive, if he turns his camera off, if that might help his audibility.
That is fine with me now that he's been sworn in. Judge, is that fine with you?
Yeah, that's fine. It sounds to me like the mic is not quite catching up with him. So he starts talking, it doesn't catch it right away. So we could try cutting the video and see if that helps.
Okay, will do. Thank you.
All right. And so Ms. Myers had authored Exhibit 101. Was that right?
Yes, Judge.
Okay. And are there any objections to admitting Exhibit 101, which is Mr. Murray's rebuttal testimony? Hearing no objections, Exhibit 101 will be admitted to the record. And Mr. Murray is now available for cross. And we will be starting with Evergy. And I think Mr. Hack or Mr. Zobrist, I'm not sure who was talking
This is
before.
Mr. Hack.
You'd indicated no questions, sir. Is that right?
That is correct.
All right. Missouri Industrial Energy Consumers, any questions for Mr. Murray?
No questions, thank you.
Thank you. And Midwest Energy Consumers Group
No questions.
and Sierra Club.
No questions, Your Honor.
Renew Missouri.
No questions, Judge.
Office of the Public Counsel.
No questions, Judge. Thank you.
Thank you. And National Housing Trust.
No questions. Thank you, Judge.
All right. Thank you. Will the commission have any questions for Mr. Murray today? I'm going to check my email, see if anyone's trying to get through to me. I do not see any questions coming through from the commission at this time. Okay. We did not have any cross. Unless anyone has anything to ask, I think that Mr. Murray has done his job here today.
Thank you.
All right. So, Mr. Murray, that will conclude your testimony. Thank you very much, sir.
Well, Judge, if you're ready, staff
Thank
would
you.
call its next witness, Robin Cleathermos.
Yes, I think we're ready to go. I haven't seen that witness. Are we going to hear from that witness or see her today?
I think we might be doing both, but we'll give it a try here.
Okay. I see Ms.
Robin,
Cleath.
I'm here. Okay.
All right. Is it Cleathermos?
It is Cleathermos, yes.
Okay, thank you. Ms. Cleathermos, could you raise your right hand, please? Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth?
I do.
Thank you very much, Ms. Myers. You may proceed.
Thank you. Ms. Cleathermos, please state your full name for the record.
Robin Cleathermos, Kleithermes.
Thank you. Where are you employed and in what capacity?
I am employed at the Missouri Public Service Commission as a regulatory compliance manager.
Are you the same Robin Cleathermos who prepared or caused to be prepared the rebuttal testimony that's been marked as Staff Exhibit 102?
I am.
Do you have anything you wish to correct in this testimony?
I do not.
And so with that in mind, if I asked you the same questions today, would your answers be the same?
Yes.
So is the information in these documents true and correct to the best of your knowledge and belief?
Yes.
Your Honor, staff would offer Exhibit 102 and tenders Ms. Cleathermos for cross.
Thank you very much. Do I hear any objections to Exhibit 102, which is Ms. Cleathermos' rebuttal testimony? Hearing no objections, that exhibit will be admitted to the record. And Evergy, would you have any cross-examination for this witness?
This is Rob Hack again, and the answer is no.
Thank you. Missouri Industrial Energy Consumers.
No questions, Judge. Thank you.
Thank you. Midwest Energy Consumers Group.
None, Your Honor.
Sierra Club.
No, Your Honor.
And any questions from Renew Missouri?
No, Judge.
And Office of the Public Counsel.
No, thank you.
National Housing Trust.
No, thank you, Judge.
Thank you. So we would be opening the floor for commissioner questions for Ms. Cleathermos. I'm not seeing any indications that we're going to have any at this point. This is the last call for Ms. Cleathermos. Don't believe that we're going to have anything. Thank you very much, ma'am. That will conclude your testimony today.
Thank you.
All right. And Judge, if you're ready, we can call our last staff witness, which is Natel Dietrich.
Okay, I think we can proceed with Ms. Dietrich today. I see Ms. Dietrich on the video here. Ms. Dietrich, do you want to say hello to make sure we can hear you?
Hello.
Great. All right, if you want to raise your right hand, I will swear you in. Do you solemnly swear or affirm that the testimony you will give in this hearing will be the truth?
Yes.
Thank you very much. Ms. Myers, you may proceed.
Thank you. Ms. Dietrich, please state your full name for the record.
Natel, Natel, LLE, Dietrich, D-I-E-T-R-I-C-H.
Thank you. Where are you employed and in what capacity?
I'm employed by the Public Service Commission as the Director of Industry Analysis Division.
Are you the same Natel Dietrich who prepared or caused to be prepared the SIR rebuttal testimony that's been marked as Staff Exhibit 103?
Yes.
Do you have anything you wish to correct in this testimony?
No, I do not.
With that in mind, if I asked you the same questions today, would your answers be the same?
Yes.
And so is the information in the document true and correct to the best of your knowledge and belief?
Yes, it is.
All right. Your Honor, staff would offer Exhibit 103 and tender Ms. Dietrich across.
Okay, do I hear any objections to Exhibit 103? That is Ms. Dietrich's rebuttal testimony that will be admitted as Exhibit 103. Do we have any cross-examination for Ms. Dietrich from Evergy?
Yes, Judge, this is Rob Hack again, and I have a few questions for Ms. Dietrich.
Please proceed.
Good afternoon, Ms. Dietrich.
Good afternoon.
As a preliminary kind of big picture measure, staff does support adoption of the non-unanimous stipulation agreement, correct?
That's correct.
And do you have that document in front of you?
Yes, I do.
I'd like to walk through a few provisions of it, if we may.
Okay.
Does the non-unanimous stipulation and agreement put forward additional customer protections in paragraph 16 and 18 relative to the original positions of the staff?
Yes, and I would hope specifically the agreement to continue to review and evaluate the current programs that are in place.
I think you're going to have to repeat that, Ms. You're going to have to repeat that answer, Ms. Dietrich. You were cutting out.
Okay, I'm sorry. I said yes, I would agree with that, and specifically the agreement, for instance, in paragraph 16, where the company agrees to work with staff in the Office of Public Counsel and National Housing Trust to review the existing programs.
And that paragraph also speaks to consulting with staff and OPC and National Housing Trust by the company with respect to extending its continued offer of 12-month payment plans past December 31st for small business customers and past March 31st, the end of the cold weather rule, for residential customers.
That is correct.
And does paragraph 18 add some protections related to the company's commitment to not report external to external credit reporting agencies through March 31st, an extension past the current plan of 12/31?
It does not mention the date. It does say for the position of the AAO.
I'm sorry.
And
I'm sorry.
It does not mention the date, but it does say for the duration of the AAO.
so we'll talk about that. As a general matter, unless the commission changes the date set forth in the non-unanimous stipulation and agreement, March 31st, 2020 is the termination date of the initial deferral period, correct? 2021, I'm sorry.
Yes, that's correct.
Okay. And as an additional customer protection mentioned in paragraph 18, the company has agreed to continue waiving late payment fees through that same period?
That's correct.
And an additional customer protection provided in that paragraph is the waiver of reconnect fees that would commence with the effective date of the commission's order approving the stipulation agreement and run through March 31st, correct?
That's correct.
In your opinion, is the adoption of these additional customer protections a reasonable outcome?
Yes, it is.
And in particular, the commitment of the company to consult with staff, OPC, and NHT regarding additional customer assistance programs and the potential continuation of 12-month payment plans. Do you think that that's reasonable in light of the level of uncertainty regarding the pandemic in place?
Yes, I do.
Does the non-unanimous stipulation agreement put forward additional reporting requirements relative to the original positions of the staff?
Paragraph 9 discusses the reporting requirements.
And is it fair to say that items A through I of paragraph 9 have generally been provided by the company to staff and OPC from early on in the pandemic?
Yes, it is.
And does that information that would be reported allow for a look at customer payment behavior and practices?
I think that's a fair characterization.
Now, paragraph J of paragraph 9 calls for the reporting of accounts receivable balances, including balances that are subject to payment plan agreements. You see that?
Yes, I do.
And would you say that that information allows for a look at the risk that the company may be exposed to associated with these extended payment plans granted under the pandemic?
I don't know that this is the actual or the correct word, but I would agree that it allows parties to look at the company's exposure.
Thank you. In your view, is the reporting called for in the non-unanimous stipulation agreement reasonable?
Yes, it is.
So just a couple of more questions. Do you have sufficient information to provide the commission with maybe an assessment or a comparison of the measures taken by Evergy to assist customers with the pandemic, prior to engaging in full AAO negotiations, compared to measures taken by Spire and or Missouri American Water relative to their negotiations on the AAO?
I'm familiar with all three companies. Off the top of my head, I don't remember the exact timing and the comparison of the programs, but I am comfortable in saying that Evergy was proactive in its response.
And I don't want to put words in your mouth, Ms. Dietrich, but compared to the other two companies that we've seen, was Evergy more proactive, less proactive, or the same, in your general opinion?
I think I'd have to do more research before I would be comfortable putting that kind of adjective on it, or any kind of adjective on it.
Okay, fair enough. So why in this stipulation and agreement, if you can answer, did staff agree to the secondary deferral period for uncollectibles in this case?
That I cannot answer.
Very good. I believe that is all of the cross that I have. Thank you.
Thank you.
Is there any cross from Missouri Industrial? Actually, what I'm going to do first before we proceed, Ms. Dietrich, are you using a speakerphone?
Yes.
Okay. I think what we probably should do is disconnect whatever your video is and stop using the speakerphone and just use a phone in a normal way, because there's an echo that's making it hard to understand you today. Could we give that a try?
Sure.
So once you have your speakerphone turned off, will you just,
and then better?
I think so. And then you have no other connections. You're not running the web stream, for instance, or otherwise connected to this call. Your only connection is your phone.
I can still see the video.
Okay, well, I do think the audio seems better to me. Ms. Bench, is that better for you? Okay. Do we have any cross-examination from Missouri Industrial Energy Consumers? And actually, the other thing I'm going to ask is that the KC conference call group mute their line. Okay.
No questions for Ms. Dietrich.
Thank you. And Midwest Energy Consumers Group?
No questions, Your Honor.
Sierra Club?
No questions, Your Honor.
Renew Missouri?
No, thank you, Your Honor.
Thank you. Office of the Public Counsel?
Thank you, Judge. Ms. Dietrich, good afternoon.
Good afternoon.
Did you hear me asking Ms. Bolin about the cold weather rule?
Yes, I did.
Can you speak to the cold weather rule?
Generally, it depends on how specific you want to get.
When can customers apply for protection under the cold weather rule?
The cold weather rule runs from November 1st through March 31st.
And what are the payment obligations for customers? Sorry, let me rephrase that. What is a customer's payment obligations when they're under the cold weather rule? Ms. Dietrich, did you hear me?
Yes, I'm sorry. I'm going through the rule to refresh my memory. The customer must pay at least 50% of the actual bill for usage during the billing period, or any level bill amount that they have during the period.
And the remaining 50%?
I believe it's amortized, if you will, over 12 months.
Is that similar then to a 12-month payment plan?
It would be similar, yes.
And this is offered by the commission, not any particular utility, correct?
It's not offered by the commission. It's required by commission rule.
Thank you for that clarification. Ms. Dietrich, when preparing your testimony, did you review deferral accounting orders in other states?
I did not.
Since writing your testimony, have you reviewed other states' deferral accounting orders regarding COVID-19?
I have not.
Did you review the Kansas Corporate Commission's order granting Evergy Kansas's requested COVID-19 related deferral accounting?
I have not.
Did you review? So right now you cannot speak to any other commission order as to compare it to the stipulation that staff is supporting.
That's correct.
Thank you. No further questions. Oh, I really hate to do this, but I actually just remembered something, Judge.
Go ahead.
Ms. Dietrich, Counsel for Evergy asked you why staff had agreed to the second deferral period for bad debts that is included in the stipulation and agreement. And I believe you remarked that you can't answer that. I want to ask
Cannot.
why. Sorry, could you repeat that?
Cannot. That I could not answer that?
I'm going to wait to see if the court reporter nods that she got it now.
One more time.
Ms. Dietrich, could you repeat what you just said?
I said that my response was that I could not answer that.
Thank you. And I want to ask you, why could you not answer that question?
I was not involved. Well, I was involved in the review of the entire stipulation and agreement, but Ms. Bolin was more directly involved in the accounting, if you will, aspects of it.
No further questions. Thank you.
Do we have any questions from National Housing Trust? And
I have no questions for the witness. Thank you.
thank you. And we would open the floor to commissioner questions at this point for Ms. Dietrich. I don't see that we have any of those coming through. I can ask a question about reporting. And I'm wondering, Ms. Dietrich, if you're familiar with some recommendations for reporting that were made by the witness or one of the witnesses for Office of the Public Counsel, Dr. Mark. Is that
Yes.
something that you're familiar with?
Yes.
Okay. And I believe that your testimony in surrebuttal was filed before the parties in this case reached a non-unanimous agreement. So
That's correct.
okay. And then in your rebuttal or surrebuttal testimony, you did address the appropriateness of some of the reporting recommendations that were being made. And so my question is whether staff's position had changed on what kind of reporting is appropriate.
In response to Dr. Mark, a lot of what he recommended was included in the stipulation or similar to the stipulation. And so we support the reporting requirements that are included in the stipulation.
And I apologize if you've been asked this question already. So is it your opinion that is the reporting requirements in the stipulation are adequate and additional reporting isn't necessary?
Yes, I believe the reporting requirements in the stipulation are adequate.
Okay. Is there any recross for Ms. Dietrich today from Evergy?
Rob Hack here, no, thank you.
And Missouri Industrial Energy Consumers, anything for you?
No questions, thank you.
Midwest Energy Consumers,
No, Your Honor.
Sierra Club,
No, Your Honor.
thank you. Renew Missouri,
Oh, Your Honor.
and Office of the Public Counsel,
No, thank you.
National Housing Trust.
Thank you, Your Honor.
Ms. Myers, did you have any redirect?
No redirect, Judge.
Okay, thank you. Ms. Dietrich, thank you very much for appearing today. That concludes your testimony at this time.
Thank you.
Okay, so we are at about 4:39 in the afternoon. I think that my preference at this point would be to close the proceedings for the day and pick up, although I did just see a probably witness drop his head in dejection at that news. And I'm assuming that that is the one witness that Mr. Woodsmall and Ms. Plesha were hoping to present. So I hate to see people disappointed.
I appreciate that.
So I understand initially the plan was that this witness needed to appear today, and then I was informed it's okay, he's also available tomorrow. Is there a strong preference to have this witness appear this evening before we close?
Your discretion, Your Honor. We can make him available tomorrow.
Well, it's 4:40. So, you know, we can certainly go for another half an hour very easily. I just don't know how long it's going to go.
We can get him started and we can stop whenever you're ready.
Judge, if it's any assistance, OPC has no questions for Mr. Meyer.
Sierra Club will have no questions either.
All right, well, let's go ahead and try to get going with this witness because it's not 5 o'clock yet. So does anyone need a break before we start with this witness? All right. So let's go. I understand this witness is Greg Meyer, and this witness is offered by 2 parties. So how are those 2 parties handling that?
I'll be sponsoring the witness, Your Honor.
We're both sponsoring the witness, but I find if Mr. Wismall wants to go ahead, and also I had mismarked the exhibits as 300 and 301. If I were marking them for MIC, I would mark them as 900 and 901. However you want the record to reflect that, but I'm fine if Mr. Wismall wants to go ahead and tender the witness, et cetera.
Okay. It seems, I'm not sure, other people might be of a different opinion on this, but I think if the record reflects the fact that this witness is being presented or offered by 2 parties, I don't know that it's necessarily that we also need exhibits reflecting that as well. Is that something that you're comfortable with, Ms. Plesha, that there would be one exhibit? Or are you more comfortable if your client has their name on this witness's testimony as far as an exhibit goes?
Well, Judge, I think maybe the solution, I would prefer that the MIEC be in the record as having be a sponsor of the exhibit. But if it's possible to just add that in the record as, you know, just adding the MIEC's name, I think we can refer to the same exhibit. So it's the same exhibit, but maybe changing the title of it so that it's clear that it's sponsored by both parties. That would be helpful. If that works.
Yes, I think we can do that. And I believe the cover page for this witness's testimony also makes clear this witness appears on behalf of both of these parties. So we'll make sure that the exhibit label reflects that. The record is going to reflect that based on this discussion, and references in the written record will reflect that. So I think we're covered.
Thank you.
That would, I don't think that requires you to submit additional documents with additional exhibit labels, since we've all gone over that now. Does that work for you? Okay.
Thank you.
All right. So my understanding is Mr. Woodsmall going to present the witness?
Yes, Your Honor.
Okay. So I'm going to just ask Mr. Meyer to raise his hand. I will swear him in, and then I'll let you take over. So, Mr. Meyer, do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you very much, sir. You may proceed.
Thank you, Your Honor. Would you state your name for the record?
Greg Meyer, M-E-Y-E-R.
And who are you employed by and in what capacity?
I'm employed by Brubaker and Associates, and I'm a principal with the firm.
And has Brubaker and Associates, more specifically you, been retained in this matter?
Yes.
And did you cause to be filed what has been marked as Exhibit 300 rebuttal testimony and 301 rebuttal testimony?
Yes.
Do you have any corrections to make to those pieces of testimony?
I do. On page 4 of my rebuttal testimony, line 3, the word expectation should be exception. And that makes the definition from the USOA correct.
Do you have any other corrections to make?
No.
If I were to ask you the same questions today, with that change, would your answers be the same?
They would.
And are those answers true and correct to the best of your knowledge?
They are.
Your Honor, I'd offer Exhibit 300 rebuttal testimony and 301, Mr. Myers, sir, rebuttal testimony, and tender the witness across.
Thank you very much. So you mentioned that you have a minor correction. Is that reflected in the exhibits that were circulated among the parties, or will that document be provided later?
We can file it again. No, it was not in what we circulated. Typically, we just make those corrections on the record, but whatever you prefer.
Okay, well, sometimes I've seen a corrected document filed, so.
A lot of times, if there are extensive corrections, a party will file a errata sheet, file corrected testimony. A lot of times, if it's real minor like this, we just make a change on the record.
I see. Thank you. All right. So, and you've offered MECG 300 and 301. That's the Meyer rebuttal and Sir rebuttal. Neither of these had any confidential portions. Is that right?
No, Your Honor, they don't.
Okay. And then as we discussed before, this is also offered by Missouri Industrial Energy Consumers as well. So these exhibits will be marked accordingly. So taking the correction, noting the correction, does anyone have any objection to these exhibits being admitted to the record? There are no objections, so exhibits 300 and 301 offered by these two parties will be admitted to the record.
Thank you, Your Honor. Tender the witness.
Thank you very much. Does Evergy have any cross-examination for Mr. Meyer?
Judge, this is Carl Zobrist. I have just a few questions.
You can go ahead, sir. Thank you.
Okay. Mr. Meyer, I just have a couple of questions about the non-unanimous stipulation and agreement. Am I correct that in section 2, there are 4 categories of costs that are to be included in the deferral?
That's correct.
Okay. And am I correct that as far as the 12-month plan that Evergy has offered, that is set forth in paragraph 16 on page 8 as to be concluded on December 31st, 2021, but it should be 2020 at the bottom of the final line of that section. Do you agree with that?
I agree with the date, the change in the date, yes, on that page, yes.
Great. Now, let me ask you some questions just about the first deferral we have referred to as the primary deferral. Am I correct that is to last from March 1, 2020 through March 31, 2021 for a period of 13 months?
That's correct.
And that's about a month longer than the proposal in your rebuttal. Is that true, sir?
Yes.
But it's much shorter than the proposal that Evergy initially proposed in the application. Is that correct?
It definitely is shorter, yes.
Okay. And the costs of the customer assistance program and any others would be eligible for deferral if approved by the commission.
Yes, pursuant to paragraph 2C.
And they would be offset under paragraph 7 of the non-unanimous stipulation and agreement by a series of savings that are set forth there.
That's correct.
And then there is what we call the secondary bad debt expense, AAO, that will continue for 2 more quarters beyond March 31st, 2021, correct?
That's correct.
And that will be determined on a quarter-by-quarter basis. Is that your understanding?
Yes.
And there are a series of amounts from Evergy Metro and Evergy Missouri West last rate case that are part of the comparison that is set forth in this secondary AAO. Is that correct?
Could you repeat that question?
Yeah, there, in Exhibit 1 to the stipulation, there are figures of bad debt from the last rate cases that are to be compared with the actual net write-offs that occurred during the deferral periods. Is that correct?
That's correct, pursuant to the totals and Exhibit 1.
And you've examined the figures in that exhibit and found them to be true and correct?
We submitted data requests to verify that those totals are correct.
And if actual net write-offs per quarter exceed net write-offs from the last rate case by 10%, such amount would be deferred in a regulatory asset. Is that the way it works?
Yes, if the test is that for the quarter, the bad debt write-offs exceed what is reflected in Exhibit 1 by 10%, greater than 10%, then it's allowed to have deferral treatment for that period.
And by contrast, if net write-offs in the last general rate case exceed actual net write-offs per quarter by 10%, that amount would be an offset to any regulatory asset. Is that correct?
Correct, similar to the treatment for savings that would be in the first deferral period, yes.
And there are also provisions in the stipulation for an extension of these programs, either if the parties agree or if they don't, if someone asks the commission and the commission approves, they may be extended.
For the main, what I call the main deferral period, if the pandemic is still present and the parties agree, then it can be extended, or the company can seek extension through a commission order.
Okay. And am I correct that both MECG and MIEC support the provisions of the non-unanimous stipulation and agreement as a reasonable outcome?
Yes, otherwise we wouldn't have supported it.
Okay. Thank you. No further questions, Judge.
Thank you. Do we have any cross from staff?
Questions, Judge?
And that was no, I think you got cut off.
Questions?
Thank you. Sierra Club?
No questions, Your Honor.
Renew Missouri?
Well, thank you, Judge.
Office of the Public Counsel?
No, thank you.
And the National Housing Trust?
Yes, Judge, I have some brief questions.
Okay, please proceed.
Afternoon, Mr. Meyer.
Afternoon.
Do you have your rebuttal testimony in front of you?
I do.
Wondering if you can turn to page 6.
I'm there.
Okay. I'm looking at the sentence that begins on line 7. You stated that you believe NHT witness Mr. Colton was, quote, using the pandemic as an opportunity to introduce permanent customer payment plans to be implemented for the future, even beyond the terms of this pandemic, end quote. Do you see that?
I do.
On what did you base this statement?
You have to give me a minute.
Okay.
Page 72 of Mr. Colton's rebuttal testimony, line 5, and I quote, "For reasons I outlined below, the offer of these payment plans should extend indefinitely." That's one example. I think there's
Okay, and do you take to mean indefinitely for the term of the pandemic crisis, or indefinitely without qualification?
I took that as to be an indefinite, meaning it did not stop with the end of the pandemic. I think there's other examples in Mr. Colton's testimony where he refers to the permanent solutions of programs.
There's another piece of your testimony that I'd like you to turn to.
Sure.
On, let's see, page 7 of your testimony.
Okay.
Page marked as 7, rather. I'm looking at the sentence beginning on line 2. You're talking about the National Housing Trust's testimony regarding the use of energy efficiency to reduce arrears. And you say, therefore, to the extent that its positions were not accepted in that MIA case, meaning Evergy's most recent MIA case, NHT is attempting to use this docket as another bite at the apple. Do you see that?
I do.
And what did you mean by another bite at the apple?
In the energy efficiency case, the MIA case, I'm sorry, your witness was Ms. Brink, and she testified that the energy efficiency programs dedicated towards low-income customers was significantly underfunded, and she said it needed to be increased significantly. And then she used the rationale for that as a reduction for uncollectibles. I looked at that, and then the testimony of Mr. Colton, and it seemed that those were in similar, or lined up similarly, or aligned up, and that's where the quote for the another bite at the apple came from.
Has Mr. Colton proposed increased energy efficiency funding in this case?
My understanding that he asked for another $1 million of weatherization to be used.
Is that the purview of a MIA case?
I don't know.
Okay. Okay, no further questions. Thank you very much.
Thank you very much. Do we have any questions from the commission at this point? Not seeing anything. Let me check my email really fast. Okay. Okay, so is there any recross from Evergy for Mr. Meyer?
No questions, Your Honor.
Any recross from staff?
Judge?
Yes. I think your first word keeps getting cut off, so all I hear is judge, but I think I know
Sorry
what you're
about
telling
that.
me. That's okay. And then Sierra Club,
No questions, Your Honor.
Renew Missouri. Haven't heard from Renew Missouri, but Office of the Public Counsel or National Housing Trust. Anything else you want to add?
No, thank you.
Thank you, Judge.
Thank you. Is there any redirect from the two parties who've presented this witness today?
No redirect.
Your Honor.
And that was from both of you at the same time. Mr. Woodsmall said no redirect, and Ms. Plesha also said no redirect. Okay, Mr. Meyer, thank you very much. That concludes your testimony.
Thank you, and thank you for letting me get in tonight.
Of course. I mean, it's only 4:58. What was I thinking? I just didn't know how long it would take. All right, so where we are right now in the process is that we have more than half of our witnesses have been taken care of. It looks like we could come back and take care of the remaining witnesses tomorrow morning. Does anybody have anything that they would like to discuss before we close the proceeding for the evening?
Judge, just logistically, can we use the same link in to get to the WebEx tomorrow, or do we have something new that we need to use?
It should be the same. It's actually possible to create a recurring meeting in WebEx, and so that's what I tried to do. So we'll be testing that tomorrow morning, but my understanding is that it should work.
Thank you.
So I will not be leaving my computer up and running all night long. I will be shutting it off and reconnecting in the morning. And I'm usually on about 30 minutes before a hearing gets going. Okay?
Are we starting at 9 again?
Yes, we will start at 9 again tomorrow morning. Any other questions?
Are there any objections to any of OPC's witnesses being taken out of order tomorrow? We're ready to start at 9, but unfortunately, I just can't confirm or deny anything right now, but I'm just checking in now.
I have no problems.
Thanks, everyone.
And that was all? Okay, so we are, sorry? I cut somebody off.
I was just saying it's exactly 5 o'clock.
I know, look at this, masterful, huh? Okay, so thank you all. We are now off the record, and you all have a great evening. I'll see you in the morning.
You too.
Thank you, Judge.
Your Honor, Mr. Robertson's going to be here for Sierra Club tomorrow.
Great, I will be looking for him.